ಇದು ಮೇಡಮ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಇಲ್ಲ ಮೇಡಮ್ ಅವಾರ್ಡ್ ಎಂ.ಎಫ್.ಎ ಎ.ಡಿ.ಬಿ 2022 ಇಲ್ಲೇ ಬರುತ್ತಲ್ಲ ಮೇಡಮ್. ಓ ಮೆಮೋದ ಮೇಲ ಈಗಲೇ ಕೊಡೋದಾ ಮೇಡಮ್ ಬಂದ್ಮೇಲೆ?
Yes.
For adjournments, page number 3, 15 to 17.
My lord, serial number 15, my lord. I appear for the appellant, my lord. Seniors facing some inconvenience today, my lord. If it may be had next week, my lord. I've informed the respondents.
No, you must. Who is the respondent?
Mr. Sri Hari, my lord. I've informed him.
You have any objection, ma'am?
It could be taken up next week.
Well, next week not possible. Yes, a request for adjournment is made on behalf of the counsel for the appellant. Re-notify. Are the submissions here on record?
My lord,
Submissions?
written submissions, my lord.
Yes, sir.
Yes. You have filed it, ma'am?
I've not filed any synopsis.
Yes,
Sir.
the parties to file their written submissions along with the judges.
Please, ma'am.
Yes,
And interim order may be extended.
interim order if any to continue.
29th January.
Much,
My lord, serial
much
number
obliged.
6. My lord, serial number 16.
Just one
Wait,
minute,
wait.
ma'am. Just one. Yes. Which number?
Serial number 16, my lord.
Yes.
My lord, a short accommodation may be kindly
Why?
provided. Lord, senior is not available today.
Date given matter.
Hmm?
Date given matter.
These are date given matters.
Please, ma'am.
You have read the file?
My lord, I'm not so well versed with the facts of the case.
We will not dismiss it in the absence of your senior.
Please,
But
ma'am.
you must go through the file. We'll just pass on.
Please, ma'am.
Okay, go through it. Yes, ma'am.
Page number.
Number 17, my lord.
Yes.
Hearing on behalf of the counsel for the petitioner, he is not in station. Short accommodation.
Okay. Who is the other side? Did you mention?
I think he must have informed me, Lord. She has asked me to do it. I have not informed, Lord.
Who
I-
must have?
Yes.
Informed or not?
Do
do
not
one
to my
thing.
knowledge.
We'll do one thing. Let the counsel come. Well, then we will adjourn it.
Please.
Okay? Not in his absence.
Yes.
Page
Okay,
number
yes, ma'am.
4, 18 to 22.
My lord, serial number 20, my lord. I'm up here for the appellant.
Which ma'am, which number?
20.
20. Yes, tell us.
Some inconvenience to the senior, my lords. A place of week time, my lord.
What is that?
Some inconvenience today to the senior.
What is the inconvenience, ma'am?
Vide Shivakumar.
No, for the appellant, my lord.
Okay, there is not date given, huh? Just say at the request of, you are for the,
Appellant, my lord.
you have informed the other side.
Yes, ma'am.
At the request of counsel for the appellant, re-notify. She states that she has informed the counsel for the respondent.
My lord, serial number
Two.
21, my lord.
Yes.
My lord, I am for the respondent, my lord. My lord, on the previous occasion, your lordship was directed to seek instructions of the client whether we could settle the matter. This is whether the excess TDS was claimed and even along with interest. We have got instruction from the client to contest the case on merits, my lord. I need a week's time to file my written submissions to this matter. I've informed.
Your lordships have heard, my lords, I have no objections for your lordships may kindly have it on Monday, my lords, because your lordships have heard it.
What was the issue, Mr.
My lords,
Dilip?
there, he had filed written, my lords, declaring 1 crore 88 lakhs. Subsequently, central government had revised his salary and salary was downgraded, my lords, to 1 crore 26 lakhs. Now he's claiming refund of the tax paid.
But
my lords,
was
the
delayed
interest-
also.
My lords,
Was it delayed?
It was
please, my
delayed.
lords, they had not filed returns within time. They had filed returns after 7 years. As per the circular,
We
within
will
6 years.
hear it. We'll hear it.
Well, a week's time, because my lord, we are on our part as well, we have made various representations to the department to consider our revised returns.
It's all right.
I would
We'll
like
hear
to-
you.
my lord.
We'll hear it today. Possible?
If a date may be fixed along with my written submissions, I would like to argue, my lord.
Very well.
Lordships may kindly, on Monday, lordships.
What is the position Monday, ma'am?
19th.
The counsel for the appellant states that though time was taken to take instructions, as per his instruction, the appeal need to be argued. Okay. Noting the said submission, re-notify on. Brief note of submission shall be brought to the court by the counsel for the parties on the next date of hearing.
My lord, may kindly permit me, I am the advocate on record in the previous writ petition.
In which matter?
In the same matter, my lord.
21.
Yes, my lord. I would like to make a submission to this honorable court.
Yes.
There is no delay. In fact, what the counsel for the department is submitting, according to me, there is no delay because the
So
downgrade.
then we will hear you then.
Yes, my lord. It will be very clear if I make about a 3 minutes submission. That's all.
Okay, then we'll just pass over. We don't adjourn it.
Please, ma'am.
Page number 5.
And notice has been.
You will not have the botheration of filing the written submissions.
Yes, ma'am. Please. Much obliged.
Okay.
Page 5, 23 to 28. Page 6, 29 and 30.
All the list, ma'am.
Serial number 1. Sri Roshan Judge.
Just say this objections.
I appear for the appellant, Your Lordship. I apologize, there was some delay in getting the objections complied with. It is all ready. If 3 days time may be granted, I will comply with
When was the last time given?
it. There was some confusion in the registry about the DCF that was paid. They had informed me that the DCF, the DD was missing. It has now been clarified that DD has been filed.
As a last opportunity, 6 weeks are granted to remove the office objections.
1 week time itself is enough, more
No,
than.
we still will give you 6 weeks. If the objections are not cleared within 6 weeks, the appeal stands dismissed without reference to the court. Okay?
Much obliged.
Serial number 2, Shri Satish K.
I'm appearing for appellant, my lord. I need to take
Yes.
steps with regard to deceased R2, my lord. I'm
He has
unable-
expired.
Please, my lord, R2 has expired.
Yes.
I need to take steps, my lord. I need to file necessary applications.
Why don't you file it?
My
Why
apologies, my
that
lord.
long? When was the last day?
I'm unable to establish contact with my client, my lord. I'm requesting for 1 week time, my lord.
Space for non-prosecution.
1 week time, my lord. I'll file necessary application with you.
Counsel for the appellant states that he shall file application to bring the LRs of respondent number 2 on record.
Please.
Stop as the last opportunity, 6 weeks are granted. Otherwise, the appeal qua respondent number 2 shall stand abated.
Please, my lord.
6 weeks, fine,
Fine, my lord. I'll file in that period.
re-notify.
4th of February.
Please, my lord. Great.
Serial number 3, Shri Gautam.
Milords. Milords, I shall take out process once again, Milords, by producing a fresh address. The address was the one that was in the.
In the report. Just say that on the counsel for the appellant furnishing fresh address of the respondent, comma, notice shall be issued for service returnable on
5th of February.
Obliged.
Serial number 4, Shri S.
Appear for the appointment. I kindly peruse order dated 2/11/23, my lord, wherein I was directed to deposit 50% before the trial court. Accordingly, I have deposited, and submission was also made on 16/11, my lord. 16/7/2024. That was noted. Despite of that, the office is raising the objection.
in spite of that.
The office is raising objection that I have not deposited the 50% of the amount before this honorable court.
But what did you do to show that you have deposited the amount?
I will file affidavit, necessary affidavit I will file.
When did you file it?
Within 2 weeks, within 1 week I will file, man. Within 1 week I will file.
See, the registry is not aware, no? You have deposited in the trial court.
No, I was directed to deposit before the trial court itself, my lord. Trial court before the trial court, I was directed to deposit.
Any receipts for having?
I will secure the receipt and file it before the registry.
That's why they were waiting for it.
No, but the office is saying I have not deposited 50% before this honorable court.
That's what.
We are ready to hear the matter, madam. Argue the matter.
Huh?
We'll argue the matter itself, my lord.
Pardon?
We'll
ready to
argue the
argue the
matter
matter.
itself, my lord.
Let's see that. If you are ready, what is the issue?
1 week, man. 1 week.
2017.
Let's see this. We take on record the submission made by the counsel for the appellant that the deposit as directed by this court, video order dated
2/11.
2nd of 11/23 has been complied with in as much as he has deposited the amount before the trial court. Full stop. Now, this arises from suit. How much is the decretal amount?
6 lakhs.
6 lakhs, my lord.
We'll hear it. Pass over. Just look
My
into the
my lord,
file.
next Monday, my lord, next Monday.
Just look into the file. Just hear it. Let's see.
It's
No,
total admitted facts. my lord.
One submission, my lord. The stages for passing on us, I was not ready. It may take on Monday, my lord, I'll get ready and file necessary.
Monday is not possible. Then it
Tuesday,
will
my
go.
lord.
Then it will go.
Tuesday, my lord.
Just say that at the request of counsel. for
Admitted
the
facts, my
appellant,
lord.
re-notify. Just give our original date.
4th of February,
Next,
serial number
Date.
5.
4th February.
4th, serial number 5, Ashok.
Take my lord.
For appellant, my lords, praying for a week's time to take steps, my lords.
Respondent to R2.
Yes, my lords. My lords, I appear for respondent number 1. I filed my IA for early hearing in this matter. IA note has been served on us, my lords.
Just 1 minute. Fine. Where's the parties, man? What is the address? Ma'am, it says insufficient address.
Lords will take steps.
Just say that on the respondent number 2 is still unserved. Full stop. On the learned counsel for the appellant furnishing the fresh public complete address of the respondent number 2, notice shall be issued to the said respondent returnable on.
My lords, may I make submissions on my IA for early hearing? That application not
I
has been
early
served.
hearing, tell us.
My lords, I had instituted the money recovery suit, my lords, against the defendant. The suit has been decreed, my lords. While order dated 14/3/24, the execution instituted by me has been stayed, the execution petition, my lords. They were directed to deposit 50% of the decretal
have
amount. The
done
same
that?
has been deposited, my lords. 1 minute. They have deposited, my lords, only 50% of the principal amount excluding the interest, my lords.
What does the order say?
Lords,
Say 50% of the decretal amount.
my lords, the decretal amount is inclusive of the interest, my lords.
Where? See, interpretation.
My lords, we have filed a memo to that effect before the execution court also. But my lords, here in the commercial AP, my lords, I have not even served a copy of the commercial.
Take it. Just give her
Lords,
a
they may be
copy.
directed to serve a copy.
Give her a copy of the appeal.
It is already served,
Not
Lords, through the.
And it's just a matter of one copy. Why don't you send her an email?
Lords, we will.
Give
do-
your email, she will send it to you.
We will
Just
send-
send it. What is there?
Early hearing application also, they not.
Re-notify. But have you filed any application for withdrawal of that amount?
No, my lords, we have
File
not.
that, do that.
My lords, failing the deposit of 50%, they had to deposit 75% of the decretal amount within 2 weeks. So my lords, to that,
There's no failing, no? They have
No, no.
deposited.
my lords,
they are
we are
dep-
disputing the amount deposited itself.
They were deposited, no?
My lords, it is not inclusive of the decree. Is
When
what.
it says decretal amount, subject to an interpretation, to be deposited, computing the interest on the date when the order was passed or otherwise. Generally, so happens when we say that computing on that day, it includes interest, the future interest, possibly pendentalized, maybe pre-reference, pre-suit. There's something, leave it at that, file an application, seek the withdrawal. Okay,
Very well.
just give the date, ma'am.
28th January. Serial number 6. Sri Prakash Angadi.
Taken steps in respect of R1, my lords.
What is the issue, Mr. Angadi?
Remanded matter, my lords. All these matters are remanded.
We'll see that. What is the
All the
remark?
3 matters.
Just give the file here. On what ground this was rejected? Popular construction.
It's not.
So Yes, what do you want? Just say this.
I've taken steps in respect of R1, my lords.
Let a fresh notice be issued for service on respondent number 1.
R2, government may kindly be ordered to take notice. And R3 may be dispensed.
Mr. Bhatt, who appears for Mr. Bhatt, who appears for 2.
Government, my lords, R2.
Just say that we take on record the appearance of Mr. Bhatt for respondent number 2. You appear for, why did you make the land acquisition officer competent NHAI as a party respondent?
Before the lower court main party. It may be dispensed, my lords. I will give memo.
You want deletion?
Please.
The learner counsel for the appellant states that respondent number 3 be deleted.
The order of 25-3 already captured.
Okay, he's been dispensed with.
Please, ma'am.
Just cut it, ma'am. Returnable date. We'll give a date.
Of February. Serial number 7, Shri Prakash Angadi. 7.
This also same.
This also same, na? Yes. Same order, ma'am.
6th of February. Serial
Respondent number 1 is not served. So
One.
what, you appear for 2?
2.
Same order.
Serial number 8.
This also. I've taken steps in all the 3 matters.
Just one. 8. Yes, 8 also same. Same.
Published.
6-2. Serial number 9, Shri Ajay Prabhu.
For responding counsel, my lords. I filed application for early hearing in this matter, my lord. I instructed to submit that IA may be allowed, my lords. Date may be fixed in month of January, my lords.
Who appears for the respondent?
Yes, my lords. I am appearing for respondent counsel, my lords.
Oh, you appear and you.
I am for appeal.
Is there that this is an application seeking early hearing of the appeal? The counsel for the respondent
Yes.
has no objection if the early hearing of the petition is allowed. Otherwise, what is the date, ma'am?
No dates.
Okay. We find, just say that, we find there is no date fixed in this petition, in this appeal. Even the learned counsel for the respondent has no objection. If the application is allowed to stop accordingly, we fix the appeal for hearing on, just give it in February. Anything there. Application disposed of. What is not served? He's the arbitrator, no? We can dispense with the arbitrator.
Please,
The notice to respondent number 4 is being the arbitrator is dispensed with. 1, 2, 3. Yes.
6th of February. Serial number.
Obliged.
Serial number 10.
Lordship, I appear on behalf of the respondents in the case.
Appear for appellant. This matter was settled in execution case. I will file the memo. Kindly give me short.
Is it settled?
Yes, Your Lordship, the matter has been settled between the parties. We will place the settlement terms on record.
We'll take your statement.
Yes, Your Lordship.
The learned counsel for the party states that the parties have settled their dispute. And as such, she intends, full stop, disputes, noting the said submission, and also you want to withdraw this?
You want to withdraw this?
Yeah,
The learner counsel for the appellant states that accordingly, the appeal be dismissed as withdrawn.
appellant.
Is ordered accordingly. Okay.
Much
This
obliged,
is-
Your Lordship.
Now, just 1 minute. This is what we have, you have withdrawn is the Jan's Sarovar Educational Trust. That's right?
Yes, yes.
Yes, Your Lordship.
Thank you.
File memo by 2:30.
Just file it during the day. Give it to her. On what, ma'am? Filing appeal,
Delay. Yes, sir.
just delay condonment and stay application infructuous.
11. Serial number 11.
Yes.
There is 32 days delay, my lord, for filing the appeal, my lord. Due to medical ground, my lord.
What do you say, my lord? Just now, what is the issue?
That money is with my lord.
Let's see, how much is the decree for?
It is the contractual amount to be paid by the Southern Railway, my lord, to the appellant.
You are ready? We can hear you.
May not be any other convenient day.
How much is the decree amount? 20 lakhs? No.
Yes, ma'am.
Two lakhs.
3 lakh, 2,000.
2 lakhs, 6 lakhs.
3 lakhs, 2,750, ma'am.
Just say that this is an application seeking condonation of 32 days delay in filing the appeal. Mr. Krishnan appearing for the, there is no serious objection. If the delay of 32 days is condoned. For the reasons stated in the affidavit accompanying the application. The delay of 32 days is condoned. Application disposed of. At the request of the counsel for the appellant, the appeal is re-notified on
30th January.
Achha, ma'am.
See number 12.
Number 12.
Yes, some more time to file objection in this case, my lord. They filed application to withdraw the amount which has been ordered by this court. I have deposited. They filed to withdraw that. I'll file the necessary application objection.
what can be the objection?
Lord, because amount which has been deposited is in disputed. That
Is?
Disputed.
is in
That may be
dispute.
right, but this is only pending appeal. They want to withdraw it. Who has filed the application?
I have filed the application, my lords. I appear for the respondent.
Yeah. How much is the amount deposited?
10 lakhs.
10 lakhs, and 5, my lords, this is not even 50% of the decretal amount,
How much was the directed?
10
but
lakhs.
10 lakhs itself, but
To complete that 50% means you mean to say that it included the interest component.
my lords, the decree required them to pay 21 lakhs plus interest. And this, what has been directed to be deposited is 10 lakhs, which is less than even the main principal amount which.
So that's my lord. 10 lakhs which has been ordered by this court, my lord. I have complied, my lord. I have
No, no.
deposited.
See the order, no?
Please, my lord.
Let's see the order.
Please.
As per the directions of this honorable court, 10 lakhs no doubt has been deposited. That too, my lords, after more than 6 months of the date being given for the depositing. In fact, this is a decree that was passed exactly 2 years ago, my lords. I've been deprived of these monies.
Where is your application? Tell us.
My lords,
File
application.
your application, but
Please.
what will be the security you will give?
Lords, we'll give an indemnity.
Bank
We'll
guarantee.
give an indemnity as required by the.
We want bank guarantee, no indemnity. That be tangible something.
Take
Instructions,
Please, my lords, I'll take instructions.
just say this. The learner counsel for the respondent had filed an application being 2 of 24. for withdrawing the amount deposited by the appellant. Just show up the file, man. I have not uploaded it. For withdrawing the amount deposited by the appellant. The learner counsel for the appellant states that she shall take instructions from the respondent from the respondent as to whether any security can be given by the respondent if the amount deposited is directed to be released in favor of the respondent. At her request, re-notified.
In the meantime, the trial court records may kindly be called for, my lords. And direction for filing the
Just say
paper book.
this, the trial court record the requisition before the next date of hearing.
The direction for filing the paper book as well. ma'am.
File a paper book. Paper book be filed before 1 week before the next date of hearing by giving a copy of the same to the counsel for the respondent. Next.
Obliged.
Sixth of February. Serial number 13.
Correspondent number 1 and 2.
Who is for the appellant?
Shri
If it
Manjunath.
pass over, we'll just come back.
Yes, ma'am.
14. Serial number 14.
So IT,
Lordship, appearing for the petitioner, matter may be passed over, Your Lordship, seniors on his legs.
what was the issue? We kept it for today.
Lords,
Ah.
it's regarding the current electricity connection and BWSSP there.
We
Please.
were to produce regulations that were passed by BW.
Pass over.
Please, Your Lord.
15 Arjun, 16 Sampath. Serial number 16.
The respondent, my lords, it may be passed on, my lords, at 2:30.
Someone mentioned the matter, no?
Yes, sir.
Pass over.
17. 17 Srinivas.
Just pass over.
18. 18 XCGP.
The respondent.
For the appellate statement. The award and the order of the 34 court, my lord, in my respectful submission, deserve to be interfered with. But the matter, an amount about 18 crores has been awarded without any evidence as to how that 18 crores has been computed. It is not even, the claim was for 27 crores. In issue number 9, the tribunal comes to a conclusion that 27 crores cannot be paid. And then on its own, without any calculation, without any support,
You both of you file your submissions.
we'll file our submissions, my lord.
And claim wise, everything, whatever your case,
My lords.
whatever this case.
Please.
They say this counsel for the parties to file the written submissions. Along with the judgment, they want to rely upon within 6 weeks. List on.
My interim order may be kindly extended.
Interim order, if
My lords,
any-
one humble submission, my lords. Honorable Supreme Court, my lords, has recently passed a judgment, my lords, wherein it has said, my lords, the state cannot be given a special concession. And even under section 37, my lord, the state should be made to deposit the amount, my lords, as required under 37. The state
Right.
has not
And was the
deposited.
stay granted in this case?
Lords, my interim order is operating since about 2022. Then
Please, my lord, specific date may be fixed, my lords.
We are fixing that.
Please, very great.
Oh, that's the law.
Please,
3rd of February.
please,
much obliged.
File your submissions.
please.
Serial number 19. 19.
Yes.
For the appellant, my lords, there's a slight inconvenience today. My lords may have it on 19th of this month. The other side has been informed. We weren't able to mention the matter in the morning. My lords may have it on 18th or 19th of this month. We'll commence our hearing then, my lords.
For the respondent, my lords.
They say re-notify on 19th as requested by the counsel for the appellant.
1912.
You are in 19th appellant
Yes, my lords.
Obliged.
in com AP 283 of 22.
My lords, in 283, I'm for the appellant.
I'll be
In
for the
242, I'm for the respondent. Oh.
In com 242 of 2022.
I don't give a name now.
Next.
The adjourn 21.
Obliged.
Delete. Serial number 21.
Please permit me.
What's the case of?
Happened.
My lord, I appeared in the writ petition. My name is shown in the writ petition.
Yes.
What I want to submit to the my lord is,
Let's before that, I make submission. My lords. This is,
Just 1 minute.
Mr. Anand.
Yes.
my lords, in this case, my lords, this is for assessment year 8-9.
Just give me some facts.
Please, my lords. This is for assessment year 8-9.
Assessment year?
8-9. 2008, 2009.
Yes.
My lords, assessee originally filed written under 139-1, my lords. That is, the original written was filed on 31st July 2008, my lords. My lords, declaring remuneration of my lords.
Within time.
That is within time, my lords. He had declared, my lords, 1 crore 88 lakhs 88,510, my lords. My lords, subsequently, my lords, there was a revision in his salary, my lords, by the central government. My lords, the salary was reduced to 1 crore 26 lakhs 19,034.
Reduced
Please, my lords, it was reduced.
to?
My lords, 1 crore 26 lakhs 19,000.
How is the salary getting reduced?
My lords, there by virtue of, my lords, there's lordships may kindly refer to page 26, my lords. Of Annexure A, page 26.
Hmm.
My lords, this is the order passed by the commissioner rejecting their application for condonation of delay in filing revised returns. My lords,
So it was reduced. When was
Yes.
it reduced?
it was reduced, my lords, on 24th April 2010, my lords.
23rd November 2010. Kindly see Annexure G.
22nd April 2010, my lords.
No, my lord. It is 23rd November 2010.
23rd,
November 2010. As per Annexure G, which copy was given
2012.
10, my lords.
2010. 23rd November 2010.
This is page 40. Where do you say? It got you have filed the salary was revised.
Please, my lords. In 2013, they bring this to the notice of AO. My lords, the proper procedure under section.
So 2006 August 2013 was the first time when you brought to the notice of the AO. Mr. Mutalli, can you hear us?
My lord, may I submit?
Mr. Kumar, can you hear us? Can you hear us?
Mr. Manoj.
I can, my lord. May I submit, my lord?
Yes.
My lord, may kindly see Annexure G. Annexure
Yes.
accompanying the writ petition, my lord.
Hmm.
There it says in para 1, we refer to the return of income filed by Subhash Menon for the assessment year 8-9 on July 31st, 2008. Copy of acknowledgement enclosed as Annexure 1, declaring income of 4 crore 3 lakhs 77,170. In this regard, we wish to bring to your kind attention that employer of Subhash Menon, that is Subex Limited, has received central government, that is Ministry of Corporate Affairs direction dated November 23rd, 2010. Copy of order is enclosed as Annexure 2, whereby an amount of 62,58,476, that is excess remuneration paid to Mr. Subhash Menon, is to be recovered from employee. Now, when the central government makes an order in 2010, then my lord may kindly see the impugned order, Annexure A, para 2. Impugned order, Annexure A, para 2. The assessee's application has been perused. Though the case is genuine and the refund claim has arisen due to the central government not approving managerial remuneration resulting in reduction of salary of the assessee, but the assessee has filed the application for condonation of delay on 25/7/2016.
But Mr. Kumar, when did you file the reassessment? When did you file the fresh assessment?
My lord, let me complete, my lord, please.
No, will you give this fact that we want to know?
The answer is very clear.
When did you file the fresh assessment after the salary gets rejected for a reassessment, for a whatever you may call it? When did you file it?
My lord, may I complete this, my lord?
Very well, go ahead.
Yes, my lord. But the assessee has filed the application for condonation of delay on 25/7/2016. Now, my lord may kindly consider this is the material proposition alleged to deny the claim is by saying beyond the time limitation prescribed as per instruction number 13 of 2006 dated 22/12/2006. Now, if the application is made on 25/7/2016, then according to my humble submission, it can be only after November 2023-2010. 6 years from this date, it can't be from 6 years from this date, because the material proposition alleged is beyond 6 years from the end of the assessment year for which the application is made. Now, if the application is made on 25/7/2016, then it has to be counted from 1/4/2017.
1/4/2000?
The central government revised in November 2010.
Yes.
Then the date has to be reckoned from 1st April 2011, because end of the assessment year which the application has to be made. From there, it has to be 6 years. So if it is counted from there, then the due date will be 31/3/2017, for which the application is filed in 2016.
So what according to you is?
This is clarified in the single judge order.
Just 1 minute, please.
Yes.
According to you, the reduction in the pay, the revision in the pay was in 2016?
No, it was in 2010.
2010.
Then I can make application within six months from the end of the assessment year from that particular date.
Okay, very well. 6 months expires on
31/3/2011.
Okay, then when can we, what is the limitation for filing an?
From that.
Pardon?
6 years from that date. That 1/4/2016.
Which provision you are saying?
Plus the circular.
That's a circular, which is the impugned order carries that reference to the circular.
That's for the 13 of 2006.
It has to be within 6 years from the end of the assessment year which the application is made. Now, if I receive an order in 2010, I can't previously make that application. I have to make it subsequently. And the limitation for me is 6 years. And the 6 years commences from 31/3/2011.
Just one. Now tell us one thing. If what would be, is it a case of reassessment?
It's not a case. It's the assessee had received salary for the financial year 7-8, my lords. So the assessment year is 8-9. Lordships may kindly note.
Tell us one thing, Mr. Dilly, you must keep it in mind, one thing. The revision or reduction in the pay was happened in 2010.
2010, my lords.
So anything, so before 2010, he could not have revised
Please,
his
my lords. Please, my lords.
return.
Please, my lords.
So it would be thereafter.
My lords, even after that, my lords, there is a delay of about in 2013, my lords, he files a letter to the AO. My lords, the circular, my lords, which the commissioner has relied, lordships may kindly see point 4. No fresh application for claim of refund will be entertained beyond 6 years from the end of the assessment year in which application.
So effectively, it is a case of refund.
Please, my
he
lord.
had deposited excess.
Please, my
salary reduced.
Please, my lord.
It's refund.
My lords, in the last date also, my lords, I made a submission, my lords. We are not disputing, my lords. It is the commissioner himself admits, my lords, we have to give refund. My lords, only thing is interest part, my lords. The interest is coming about 22 lakhs, my lords. Only the interest. My lords, there is no fault of ours.
He filed it in 2013.
My lords, that is not the requirement of law, my lords. They have to file an application for condonation of delay before the commissioner within 6 years. Commissioner has to condone the delay, only then they can file a revised return. My lords, in this case, they have not done.
Understand. Now, what is the delay that had happened?
My lords,
now refund can be sought within 6 years.
Please, my lords.
No issue.
Please, my lords. Only by filing revised return.
Now, what is the initial period of limitation? 1 minute, Mr. Kumar, you will not interfere.
My lords,
just see this, Mr. Please. What is the initial period of limitation which has expired, for which he has to seek condonation? What is the initial period?
My lords, from the end of 8-9, my lords, assessment year 8-9, 6 years, my lords, that will come up to 31st March 2015. Within 31st March 2015, he had to file application, which is not done, my lords.
No, that we will not take it.
My lords, that.
See, his knowledge is 2010.
Please, my lords, that salary was downgraded only in 2010.
That's right. So there was no occasion for him to even seek a refund.
My lords, if that is the.
So then it will trigger in 2010 for next 6 years.
Please, my lords, then they'll be within.
Then?
My lords, then they'll be within time, my lords. Only the interest part, my lords, we've not.
Tell us one thing. He gave, according to him, even also he has delayed it, but he is within his rights to come to you, seek refund for within 6 years. Just listen to us.
Please, my lords.
2013, he comes, makes an application. His case can be that there was no requirement for condonation. My time starts from 2010. It will go expire after 6 years. Within this, I am within my time.
My lords, even for claiming refund, my lords, there has to be a return, my lords. Without return, return, revised return. My lords, section 239 says that is what it says.
Very well. He has to hear right. Because unless and until there is a revised return, it is revised. There is no question of refund.
Please, my lords, even in my lords, in 2010, when they got, my lords, they had to file an application for condonation of delay before the commissioner for filing revised return, my lords.
Okay. But did he file within 6 years revised return?
He is not filed, my lords. Against the rejection of commissioner's order, he's filed a writ petition challenging that. Learned single judge, my lords, has directed us to issue refund along with interest.
Now, we just want to know, this is important. Did he file revised return? Yes or no?
No, my lords.
Yes, Mr. Kumar.
Not filed.
Did you file revised return?
No, my lord. Because we preferred violation of fundamental rights for retaining the tax more than due. So therefore, the writ was allowed, directing to view the refund, and there was no direction to file the return.
His fundamental right to refund the amount.
No. 1 minute, please.
Yes.
See, your salary get reduced. What was projected in the first return was X amount.
Yes.
X plus Y.
Yes.
Now, what has come down to is X.
Minus.
So surely you will file a revised saying that now I am entitled to this refund. That's the process which is to be undertaken.
It is a difficulty, my lord. 139.4 is the 139.5 is the revised return section.
Did you file revised return? Yes or no?
That time also gets expired. I am not unable to file revised return under 139.5 because even that time expires. So therefore, we prefer this writ petition, and which is the advancement that we are within the time to approach for condonation.
How is the time expired? From 2010,
Within 1 year from the end of the assessment year, a revised return can be filed. That has expired. By the time the salary got downgraded, the opportunity to file revised return also had lapsed. So there was a practical difficulty.
just 1 minute. If he was to file a revised return, is there any limitation within which time he has to file a revised return?
Within 1 year from the end of the assessment year. That, even that, my lord.
You need to relook all these things. There can be hundreds of eventualities. One eventuality is this. He said, where is the question? My revised return was of 2008-9. I came to know in 10.
Please, my lords.
And the limitation surely at least he will 1 year would start from 2010.
My lords, if he's missed, my lords, even filing revised return, my lords, he was well within the circular, my lords, 6 years he had time for filing the condonation application before the commissioner for getting the delay condoned. My lords, after that he could have filed a revised return, my lords, which he has failed to do in this case. And now, my lords, is claiming interest on that, which is the fault of the assessee himself, my lords, and we are saddled 22 lakhs of interest. My lords, the refund is 22 lakhs and the interest component is more than 20. It's about, my lords, what we have
Now
to
tell
pay
us,
as
let's see 139.4. Give you the IT.
9.5.
139. Lords, your lordships may kindly notice the note, my lords, because the section has been amended.
That should be filed within 3 months.
My lords, that is the amended section, my lords. Your lordships may kindly notice the down, my lords. Subsection. Here it says revise written any time before the expiry of 1 year from the end of the relevant assessment year or completion of assessment. 1 year from the end of the assessment year.
Okay, where does it say?
From 2017, my lords, the section was amended. That is reduced to 3 months.
Yeah, 53. Okay. So 1 year, within 1 year he could. Now you are taking it relating back to 2009.
Please.
March 2009 or 1st April 2009.
Please, my lords, we are taking that date.
So 1 year thereafter. So that will expire in, but he got the information about the revision in the
2010, my lords.
2010. After that 1 year also expired.
Please, my lords, after that also he had expired.
So there was no occasion for him to file it.
My lords, he could have filed application before the commissioner for condonation of delay, my lords, as per the circular, which he failed to do. My lords, only in 25th July 2016, he's filed
Where
application.
is the circular say condonation?
My lords, point 4. No fresh application for claim of refund
That's
will be.
right. For which the application made is made. Where is the condonation? The earlier page? No.
This circular speaks about condonation only.
I know. You see serial number clause 3. Application claims under 119 for condonation or delay involving refund claims exceeding 50,000.
This is monetary limit, Manoj. What has happened, Manoj? Board has bifurcated. If it's below 10 lakhs, it is commissioner. Afterward, about 50 lakhs, it's board.
Now, where is that clause for condonation?
Manoj, point 6, Manoj. At any time of
At the time of
at the time of considering the case under provisions of section 119 2B, it should be ensured that income declared and refund claimed are correct and genuine, and also the case of.
But that's not the point.
Genuine not.
Where is that condonation?
Clause 4.
Clause?
Clause 4.
It will be entertained beyond 6 years from the end of the assessment. This is only a bar beyond 6 years, no application. But where is that condonation of delay? We are talking of in the sense of the assessment file, return filed.
Please, my lord.
There was some wrong calculation, like, under 139(4), omission or wrong statement.
Please, my lord.
Within 3 months, 3 months have become 1 year now.
Please, my lord.
Where is the condonation? Now, so it's like this. If it has become 1 year, you are within your limitation period.
Please, my lords, for,
I can do it. I can file a fresh assessment or return.
please, my lords.
But if it crosses 1 year,
They have to file an application, my lords.
condonation,
Please, my lords.
where
As
is
per-
that?
Lords, the application filed by them, my lords.
Where is the power for seeking condonation
Lords, clause 1, my lord,
of?
of this circular. The
Hmm.
procedure for dealing with application for condonation of filing of
That's in
return.
modification now. The instruction is in modification.
Lords, the earlier circular I have carried. It's,
But no, this would not hold good, na? This is from 2006. It governs this present return.
my lords, this is the circular which, please, my lords, this circular covers.
So in this circular, you have to show if it is beyond 1 year, he has to file. So we take it, let's assume your submission is this. So 1st April 2009
Please, my lord.
till 31st of March 2010, he could have filed it,
He could have filed, my lords. He could have filed revised return.
revised return.
Please, my lord.
But the moment that date time expires, it has to be accompanied by a condonation of delay.
Please, my lord.
Where is that?
My lord, one small correction. If if the order is passed, then also there is no occasion to file a revised return. My lord, may kindly see Annexure D, where the order is passed on 31/3/2010, and after that date comes the downgrading of salary by the order of central government. So the limitation to revise was available to me only up to 31/3/2010, because the assessment is completed on 31/3/2010 as per Annexure D. So
Then we are asking you, Mr. Kumar, this.
yes, ma'am.
You are not disputing that any period beyond 1 year, in a normal return you have filed, you want to file a revised return. Within 1 year, you are within your time.
Yes,
If
ma'am.
it exceeds beyond 1 year, you need to file a condonation of delay.
True. That's right.
Now let's translate this provision in your facts.
There are two components, my lord.
Just
It
1 minute.
has to be within 1 year from the end of the assessment year, or it has to be before the passing of the order or giving the intimation. Now, intimation precedes the end of the assessment year date. That is 31/3/2010. I got the order. And salary was downgraded in November 2010.
Now, in your case, you came to know on a particular date in the year 2010
Please.
about the salary getting reduced.
Yes, madam. In November 2010. Whereas I received the order in 31/3/2010. The order was received by me in 2010. That is before the downgrading. So
Now, within 1 year thereafter, let's assume.
it's not 1 year. Even before the order, it can be 1 year is applicable in option if there is no order. If there is an order, then the order date has to be recorded. That is the provision of 139(5).
For revised return, when you are going to file?
For revised return, it has to be filed within 1 year, from the end of the assessment year or before the passing of the order, my lord.
Within 1 year from the end of the assessment year.
Assessment year.
No, he is referring to even an order to be passed.
Lords, that whichever is earlier, my lords, whichever is earlier,
Very well. Whichever is earlier.
please.
Let's
That is,
assume
my
that
lords,
in
1
any
year,
case, the father's date is 1st of April 2009.
please.
Now, what we want to put it, we want to ask him also. Now, we want to put it to you, Mr. Kumar. It's like this.
Yes, ma'am.
When you came to know in 2010 only,
Yes, ma'am.
very well. At least for the next 1 year, you could have filed your revised return.
No, as per 139(5), the due date will be 1 year from the end of that assessment year. That is assessment year 2008. So,
salary.
1 minute. We are saying something in your favor. Forget 2008-9. You have come to know date of knowledge is 2010. You would say, I can't go back. I can't foresee that something is coming in 2010. You're getting? So 2010 is the triggering point for you to get the return revised. 2010, 1 year expired. Before 2012, you did not file any revised return. Are we right?
And doesn't 139.5 does not enable me.
Okay, it doesn't enable you.
Yes, ma'am. That is the position. That's what is
Enable you.
also. And that was allowed.
Very well. If that be so,
ಇವತ್ತು
enable
ಮ್ಯಾಟ್ರ್
you.
ಇದೆಯಲ್ಲ ಕೋರ್ಟ್ 2 ಮುಂದೆ NCC ಜಯದೇವ ಆ ಫೈಲ್ ಒಂದು ಸ್ವಲ್ಪ ಕೊಡಮ್ಮ.
It doesn't enable you, then what really follows? What really follows is what they have said, 1 year from the date of the assessment, ending of the assessment year, you must file the revised, or from the date of the order, whichever is earlier. Okay. Now you don't file revised return with an application for condonation. You don't do that. You are required to do it because of the limitation under the provisions of the Act. So 2010 will not be a triggering.
No.
You have to relate back to 2009.
No, ma'am. My knowledge is in 2010.
Forget knowledge. The limitation under the Act, forget knowledge. It will still means you have to go back to 2009, 1 year thereafter, file an application for condonation of delay and get your return revised.
True, my lord. But then at that time, I never had knowledge.
So that's what they say, that you did not file your condonation.
Yes. I filed it within time of 6 years.
That's right. That is something that they can revise till within 6 years, provided you file an application for condonation of delay. That's how you must look at it.
As per 139.
Getting the point? What do you have to say?
My lord, the material proposition alleged is that my application is beyond 6 years from the end of the assessment year for the application is made. Now the assessment year 2008-9, it should be within the prescribed time of 6 years from the end of that assessment year. Now, if that is to be reckoned, then it comes to my knowledge only subsequently, for which the date has to be reckoned from that subsequent period. That is what the learned single judge has observed. My lord may kindly consider page para 4 of the order.
So he did not file revised return.
He did not.
Straight away not.
By the time the date has expired.
Yes, ma'am. My lord, allow me to read para 4 of the writ order. Per contra, learned counsel for the respondent submit that there is no merit in the petition and that same to be liable to be dismissed. Para 5. As rightly contended by the learned counsel for the petitioner, in light of the aforesaid judgments, so and so, coupled with the material on record, which clearly indicates that instruction number so and so was not applicable to the facts of the instant case, since the intimation dated 31/10/2010 was issued by the respondents to the petitioner, which is followed by subsequent proceedings between the petitioner and the respondents, culminating in rectification order passed on 5/3/2015. The respondents clearly fell in error in coming to the conclusion that application for condonation of delay filed by the petitioner was beyond the period of limitation, and the impugned order being not only contrary to the facts of the instant case, but also aforesaid decisions, the same deserves to be set aside and the matter remitted back to the respondents to consider the claim for refund in accordance with law by condoning the delay in filing the revised return. So there is a subsequent order dated 5/3/2015 also, which cannot be ignored for the purpose of reckoning the date of commencement of the limitation period. This is what the learned single judge appreciated, passed the order.
Now their difficulty is only this.
Yes,
the learned single judge say for refund with applicable interest, if any.
That also has been dealt by the order being impugned now in this appeal, my lord. It says that a respondent are directed to consider the claim of refund with applicable interest, if any, as sought by the petitioner in Annexure J and K, dated 25/7/2016, and in accordance with law with the period for 4 weeks, within a period of 4 weeks from the date of receipt of copy of this order. No compliance has been rendered in this matter.
What is this order of 2015?
My lords, he had filed an application. He had filed a rectification application, my lords, that it is not pertaining to this.
No, it is.
There was some arithmetical error, my lords, in calculation that relates to that. It's not pertaining to, if he has to claim refund, my lords, it is only by way of filing revised written, my lords. There is no other way for him, my lords. Even the Honorable Supreme Court, my lords, has said, my lords, without filing revised return, they cannot claim refund. My lords, your lordships may
No.
kindly refer to subsection 2, my lords, of section 244A. It says, my lords, where if the delay is attributable to the assessee, my lords, the interest, they cannot, interest has to be excluded. Subsection 2 of section 244A. And even the circular itself says, my lords, the interest, if the delay is attributable to assessee.
So what the learned single judge did is, he counted the limitation from 2010.
There's
But
nothing.
he did not look into the provision which says from the end of the assessment year.
Please, there's no finding.
Submission was to the effect that even otherwise there were other proceedings which I was subjected to, and that date cannot be ignored because those were the proceedings. It can't be ignored. 2015 onwards, in fact, I should count my date of reckoning from 2015 rather than 2010. I'm well within the time to represent that condonation should be granted to me, and that is what was held. It was a long discussion has taken place, and thereafter this conclusion, and the two citations were there. They were on merits. That is not disputed by anybody.
But see, difficulty, what we are unable to, there is a limitation insofar as the Act is concerned. The Act says that it would be still, the period of 6 years shall reckon from the date of from the last date of the particular assessment year. The 6 years starts running. And no other situation is contemplated like the situation we are in. That in 2010, when you come to know that your salary has been reduced and you are required to file a revised return, you can't do it because that says within 1 year and you are beyond 1 year. That's what is an issue.
So that's why the circular, the material proposition alleged is resting on the circular, which is inapplicable. That is what was held by the learned single judge. It's clearly stated that the circular is not applicable.
We'll just reserve it.
Please,
Okay.
please.
Thank you. Thank you.
My name may be shown, my lord. I have tried my assistance.
We have noted your name.
Please, madam. Much obliged. Highly obliged.
Yes.
Serial number 22.
In this case,
The respondent in this matter.
settlement talks are going on, my
Lords, last night I have received a proposal from them. I will respond today. Matter may be had any date next week, my lords.
The counsel for the party states that the parties are exploring a settlement. If that be so, re-notify. Just give it after 2 weeks. This in December.
1812.
Obliged.
Serial number 23. 23.
My lord, I undertake to file NOC Wakalat on behalf of the appellant. Just received information that NOC has been.
For whom?
For the appellant, my lord.
I'm appearing for
NOC
respondent number
Wakalat has been given by the previous advocate. Now I undertake to file a NOC Wakalat.
Are you ready? Can we hear this?
I seek time after vacation.
Just say that so and so appears, you are.
For appellant, Harsha Manad.
Just say that so and so appears for the appellant states that he has received the NOC from the previous counsel and intends to file wakalat, which is request re-notify.
6th of February.
Please.
24. Number 24.
I appear for the.
My lords, I'm appearing for the respondent in the matter.
Yes.
My lords, we had filed an IA for permission to deposit, to withdraw the money that's being deposited, my lords. They have not filed their objections to the application.
I make my submission.
But you were to file now, ma'am. Have you filed it?
I filed it, my lords.
In the last week, I was not well, therefore I have not filed it. Kindly accommodate me a week's time, I'll file it.
What?
The objection to that.
To the application, you were, they filed an
No,
application.
I was, last week I was not well. Today also I am not fully well.
Just have it re-notify after 1 week.
Okay.
Just 1
Please.
minute, Mr. Surana, just 1 minute. Mr. Surana, 1 minute. Just say that Mr. Surana states that the reply shall be filed on or before. Today is what, man? On or before 10th of December. Re-notify on 11th.
11, 12.
Obliged.
25.
Much obliged.
The respondent, my lords. May I seek a passover, my lords? My senior is on the way. I'm for the respondent.
Passover.
Passover.
My lord, I seek some accommodation. Today I'm not ready. We have to submit the written submissions according to the order, which we have not submitted. Both of us, there was a.
Just say that though a Passover is sought by the counsel for the appellant respondent, the counsel for the appellant states on Passover, he shall have difficulty. Adjourn to
5th of February.
Please, date please.
Yeah.
26, no?
Now 26.
26.
Passover.
27.
Yes, Mr. Naganan.
Lord, there are two sets of appeals. One said by the other side is an arbitration matter. Matter has to be heard, my lord. Last time, there was an application filed by me for production of additional documents. My learned friends had filed a counter to that, and I had short time, my lord, to file a rejoinder. The rejoinder is ready, my lord. I served them a copy. I'll file it in the course of the day.
They're contesting that.
Yes, my lord. They are seriously contesting my application for additional documents on more than one ground. So, my lord, your lordship may, there's already an order that this can be heard at the final.
How many? No, about the documents,
Yeah.
about the application.
Yes, the application could be considered along with the main matter itself. If those documents are relevant, then the honorable court may have to peruse them. They have twofold defense to that, my lord. One, they say is that these documents are all emanating after the list has arisen. So to what extent is it relevant is one aspect. Second aspect is before the amendment of the Arbitration Act, my lord, which restricted the right to file documents, these documents, the list here arose before the amendment. So that one legal issue, my lord, we may have to address, but merits will have to be heard, my lord. I think the date your lordships had given was 10th or so, but.
10th, my lords. It was directed to be
We are
listed.
given 10th.
10th, my lords. We are being led by Senior Counsel Mr. K.G. Raghavan, and we had specifically sought for 10th December. It was not supposed to be, it was directed to be listed on that date.
Maybe very well, I think, but the order sheet says 4/12 in any case. Just
Lord,
say
it
that-
may be had after vacation, my lord. 10th, I have some difficulty.
Have a 10th, because that was when it was directed to be listed. We have been served the rejoinder just today, my lords.
Just say that, no, but when do you want?
Any first week of January, my lord.
What do
Or
you say?
in-
My lords, my instructions are to be on
My
10th.
learned friend is
because-
also appearing. Mr. Holla appears for one of the appellants.
Just say,
Mr. Raghavan may not be available any other date. He's given 10th. So my instructions are
no,
10th. my
can
lord.
we have it in February, January first week? Just take the date from him so that we can accommodate him on that day.
Yes, my
Okay?
lords.
Just say this, Mr. Naganand and the senior counsel appearing for
The
which,
appellant number 2 in Company Appeal 156 of 22.
states that he intends to file rejoinder to the reply filed by the respondents on the application filed by the appellant for production of certain documents during the course of this.
Yes.
A copy thereof has been given to the counsel for the respondent, full stop, noting the said submission, comma, re-notify the appeals on. Just give the first week of. Second week. You have to tell her so that she can take a date.
Yes, my lords.
He says second week. Now take the date of Mr. Raghavan for the second week. Okay,
I'm grateful.
inform the counsel, then inform the court officer.
Please.
I'll do that, my lords.
Next.
I'm grateful.
The 60th is the resumption.
Okay, court. Great.
Yes, this is the same matter.
No, this is a section 37 appeal. On the last occasion, my lord, I am for the successful claimant before the tribunal.
I'm led by senior counsel, Mr. Srinivas Raghavan. He's on his way, my lord, seeking for a password.
We'll pass over.
Very good.
Nine. Serial number 29. Srinivas.
Pass over. It is 2:30 minutes. 2:30. All the passovers.
Passed over matters. Serial number 13. 13, P. Manjunath. Serial number 13, P. Manjunath, Shri Prakash.
Let's say pass over.
14,
Pass over.
No, I'm sorry, my
Oh,
lord.
yeah.
I'm sorry, I missed the first round. Just,
happened,
it's,
Mr.
your lordship had asked me to look into that aspect of the BWSSB. In fact, the act itself answers the issue. BWSSB Act. We have a book. We'll just pass it. I see. Section 47, my lords, my kindness.
Is only in the context of
That water meter, that's all. Section 47, if my lords were to kindly see, the two important aspects here. The board may provide a water meter and attach the same to the service pipe in the premises connected with the board. So therefore, my lords, a water meter, and it has to be attached to the service pipe. Now, kindly see how service pipe is defined under subsection 21 of section 2. Subsection.
Subsection
21. Service pipe means so much of any pipe for supplying water from a main to any premises as is subject to water pressure from that main. So essentially what this means, my lords, is there is a main pipe, and as your lordships rightly indicated orally there, this is the pipe that connects the premises to the main. So as per section 47 read with this subsection, the water meter has to be attached only to this service pipe, and you can have 100 different outlets after that. There's no question of attaching any water meter to that. Now, this is again buttressed, my lord need not see it, but there's also regulation 14 of the 1965 regulations. I'll just read it out now, just one sentence. It says no premises shall have more than one water connection. So for an entire premises, one water connection, 1 meter attached to the service pipe. That's all the BWSSB regulations provide for. But it should also, my lords, be canon enough to submit that recently in 2020, my lords, to just see, this may not.
There are instances, Mr. Vikram, I've seen where there are no meters.
At all.
At all. From main connection, water is fed, the water is fed or the pipes are fed to each of the likes of 4 floors. So main pipe, and from one pipe there is a sort of one pipe connected to the premises.
I see. I didn't.
And they charge a lump sum amount for monthly.
I see.
No meter.
No meter at all.
But technically, if you see that interpretation, then there is no meter.
There's no meter at all.
In the
Correct.
whole of the
At
building,
all. So it's just a lump sum pre-agreed amount.
Possibly this is only for this for the reason they have one pipe which is just running till the 4th floor.
Correct.
And then one pipe going inside each of the floors.
That's right. So the way I understand this, there'll be a main pipe. For example, on the ring road, there'll be a main pipe. From the ring road, there will be a service pipe that connects into, let us say, Manyata Tech Park. So the meter is attached to that service pipe as per section 47. And let us say Manyata Tech Park has 100 different outlets from there. There won't be any meter there. Except, my lords, now recently, I think due to the the shortage of water that we're recently facing in 2020. Of course, it's a very, I mean, we made this compilation much earlier, but only, which page is it? Page 90 of that. There's recently been an insertion which provides for sub-meters, but interestingly, not for the, Manoj may kindly see that, I'll just explain. Page 90, running page 90.
Yes.
Manoj may kindly see page 90. This was inserted in the year 2020. From 7/5/2020. Manoj has it at the bottom of the page. Every owner or occupier of a building having a sital area of not less than 2,400 square feet. We fall under that. Manoj may skip the remaining because it speaks of building having 3 or more houses. Every owner proposed to construct a building. Then Manoj may kindly see, shall install their own internal meters for judicious consumption of water within such date as may be notified by the state government. However, the readings of such internal meters shall not be used for billing or any case to dispute the readings of the meter. So the meter contemplated under section 47.
See, we can say this, Mr. Vikram.
Yes.
You have relied upon all these programs. And all these will be considered
by the tribunal.
Yes. Without being influenced any observation of the ITAT against you also on water connection.
My only, Lordships may recollect, my only difficulty is this. Now, virtually the tribunal has asked me to perform the impossible by producing the by producing the readings of each of the sub-meters. There are no sub-meters. So therefore, I can't, if I go back to the assessing officer, so if your Lordships were to clarify.
Your Lordships may kindly send it back to the tribunal itself.
Yes.
Let the tribunal may consider it. Lords, all.
Absolutely.
Please.
But the fact remains, if you see the ITAT order.
Lords, they are relying on.
That.
See, it can't be,
Page
it has to be
71.
purposeful now, for going back to the ITAT.
Page 71 and 72.
Every unit should be independent with independent facilities. Power connection, door number and water
Page
connection.
72, Mallards, about 4 lines from the top. Accordingly, we remit this issue for the limited purpose of verification of charges of power charges.
And your case is there are no sub-meters in this premises.
For water.
For water.
For water.
Even though units are independent.
Absolutely. And in fact, that the requirement of producing a separate reading for water is not contemplated in primal projects itself. Now, all of these observations are pursuant to a judgment we relied upon, that is primal projects. Now, there the ITAT seems to have added a condition, but even that issue may be left open, because I don't think water connection was contemplated under primal projects. We'll be able to.
Based on these provisions which you have relied upon.
Yes.
Your submission is that no such facility of having a sub-meter is provided.
Absolutely.
Or is contemplated.
Or is contemplated. Except for that 43B, but that came in 2020.
Just say this, so we will say so, but the tribunal would not go by, would decide independently without, getting influenced by this observation.
Absolutely.
He will rely upon all documents what are there.
Please.
Just say this, the challenge in this appeal is to an order passed by the Income Tax Appellate Tribunal, ITAT in short, dated 31/7/2023. Whereby the tribunal has disposed of the appeal filed by the respondent revenue by stating in paragraphs at pages 7, paragraph 7.5 and 7 as under. Full stop. A reading of the said paragraphs, it is noted that the tribunal has remanded the matter back to the assessing officer, by the assessing officer by giving a finding that the that the assessing officer shall verify the charges of the power charges and water charges on the basis of sub-meters installed in the independent unit for consumption of power and water. According to Mr. Vikram Lana, senior counsel for the appellant, that insofar as power charges are concerned, the appellant can satisfy the assessing officer based as there is an independent meter there for electricity.
Yes, madam, I believe so. I believe there will be independent.
As there is an independent meter recording the consumption with regard to the unit occupied by the appellant. But insofar as the water charges are concerned, as there are no submeters in the whole of the premises, though unit is independent, he cannot satisfy the assessing officer based on the charges on the basis of submeters. According to him, the provisions of the Bangalore Water Supply and Sewerage Act 1964 and even the circulars issued by the said board do not contemplate installation of submeters, even though in a premises having different units. He also states that the appellant is ready to go back to the assessing authority, but the assessing authority, based on the remand made by the ITAT, must decide the issue on those two aspects independently without being influenced by the observation made by the ITAT, which have been referred to in paragraph 7.6 of the impugned order. Mr. Dilip, learner counsel.
Please.
For the appellant, is agreeable to this submission made by
to the tribunal. Your lordships have said we are ready to go back to the assessing officer. We'll go back to the tribunal.
Okay.
That's the
very good. Full stop. Just say that Mr. Vikram also states that instead of being remitted back to the assessing officer, we remitted back to the tribunal for the tribunal to consider the issue afresh based on the documents to be filed by the appellant herein. You want to file any documents? You don't want. Full stop. Noting the said submission, we modify the order passed by the ITAT to the extent that the matter shall be considered by the tribunal on the two aspects on which it sought to remand the matter back to the assessing officer. Liberty is granted to the appellant to file such documents in support of his case on the two aspects. Liberty is granted to the revenue also, if need be, to file such documents as they intend to rely upon. On the filing of the documents by both the parties, the tribunal shall decide the issue to the extent on which remand was made by the tribunal to the assessing officer. Appeal is disposed of.
Grateful.
Thank you.
Obliged.
We'll just give back this. We'll just note the provisions and then. Sir. Just note this. Day of 278 days delay. Condone.
I'll leave it to you.
Delay for submission. Next. Grateful.
Number.
Next, ma'am.
16. Sampath. 16.
Yes, ma'am. You have seen the file.
Please, my lord.
What is the case?
Lord, there was.
Request for the passover, my lord.
Let's see. Just wait.
Lord, in this matter, I am appealing for the appellants on behalf of A. Sampath, my lord. There was a work order that was issued by the Mysore City Corporation to the appellant, and the appellant demanded a payment towards the pending running bills, which weren't paid, my lord, because of the delay. And there was an AC number 67/2018, which was initiated by the complainant before the sole arbitrator. And eventually the sole arbitrator awarded 20 crores, 70 lakhs odd to, in favor of the appellant, my lord. Subsequently, AS number 67/2019 filed by the respondent herein challenging the award. My lord, the Honorable City Civil Court allowed the suit in part, and this appeal is challenging the same, my lord. My lord, the crux of the matter is the question of law in this is whether under Section 34 of the Arbitration and Conciliation Act, which provides the power to set aside an award, can the award be modified to that extent? My lord, in this matter, claim number 2, 4, 6, 7, 12, and 16 have been set aside, my lord. They have been modified to that extent. My lord, the other claims have been already been claimed and has been paid off in the execution petition, my lord. Only the claims under the subsequent numbers have been challenged in this matter.
Let's see that.
Please, my lord.
Let's see the operative part.
Lord, if your lordships could go to page number 85.
How much was the initial amount given by the arbitrator?
20 crores, my lord.
And how much has, okay. And
The execution
let's-
petition has been cleared up to 16 crores.
Reduced to 16 crores.
No, 16 crores has been paid off. With respect to the other claims, my lord.
Now, let's see what does the 34 code does.
Please, my lord.
34 code says 2, 4, 16 sets aside. Amount with regard to upheld.
Please, my lord, there are two judgments which by Justice Fali S. Nariman, my lord, wherein the question was whether the power to set aside an arbitration award includes the power to modify. And
Is this a modification?
my lord, it was partly set aside, my lord.
Right? So in that sense, none of the claims have been modified.
Please, my lord.
Let's assume that he gives 600 rupees. He
Please.
said, no, it is not entitled to 100 rupees, he is entitled to 50. That's modification.
Please, my lord.
But there are 15 claims. 5 claims, all 15 allowed by the arbitrator. The 34 court says 5 claims could not have been, 10 claims could be. Otherwise, what is the position?
Please, my lord.
Though 5 claims have been set aside, he has just only set aside.
Please, sir.
But 10 he has granted, 10 he has upheld. So can you take it as a modification, which is impermissible?
My lord, even if that is said, all the claims that have been set aside are all claims that are arising out of the contract, my lord. And all these claims that is.
No, that's a different argument.
Please.
This argument of modification will not come.
Please, my lord.
So you will be arguing that he could not have set aside on merit.
Please, my lord.
What is your,
Request to pass on.
we'll have it some other day.
Please.
Please, my lord.
Just say this, the request of the request of counsel for the respondent re-noted. Give it in January.
The 3rd January,
Please.
Much obliged.
17, Srinivas.
I appear for respondent, insurance company. Stay ಆಗಿದೆ ಅಲ್ವಾ ಅದು? Subject to deposit ಅಂತ. I'm appealing for the respondent.
Yes.
Respondent, my lord. They have filed the appeal against the commercial case.
17, yes.
17. And they have not completed the order. I think your lordship has granted stay subject to deposit 50%.
Interim matter.
They have not done it.
Interim matter granted by this court.
Yes.
Did anyone present? Or?
I already filed the execution. 3 more things.
They have deposited.
Not intimated.
They say none for the appellant, even in the second call. Re-notify all.
30th January,
Record may be clear.
records.
Much obliged.
Yes, ma'am, next.
26. Viresh Buddhihan, 26.
My lords, in this matter,
I appear for my name is shown for respond number 1 and another advocate's name is also shown for respond number 1, my lord. There appears to be some confusion, which I am not also able to crack it. I request your lordship's short accommodation. In this case, I appeared in the trial court, so perhaps a direction would have been given that should be served on me. I will just check it out, my lord. I will not guess. I'll just check it out and get back to your lordships. One Mr. Nagendra's name is shown as
Yes.
the two names are there.
They say that at the request of Mr. Nagendra.
He is Mahesh.
You are Mahesh.
I am Mahesh.
Mahesh S. Verma. Appearing for the respondents re-notified. Who appears for the appellant?
Shri Viresh.
Budiyal.
Just give it.
30th January.
Publishment.
28. Lochan.
Yes.
My password, man. It's on. Serial number 28. My password, Sinaga.
We are passing over. Okay, we'll pass over.
29. Number 29. Shri Rao.
Just call again, pass over.
13.
What is this?
No, this is a matter where, my lord, there was a ex parte decree after notice. And thereafter a miscellaneous petition was filed seeking to set aside the ex parte decree. That also came to be dismissed. And we filed the execution petition, my lord. In the execution, they have admitted the liability. But they paid part of the amount, then they filed this appeal. And this court has directed them to deposit the entire amount. They did not deposit, then I filed an application seeking for injunction, restraining them from alienating those properties. Your lordships have granted the interim order last time, Lord.
What shall we do? There are no one.
Maybe taken up some next week.
None for the appellant, even on the second call, in the interest of justice, re-notify.
But the interim order may be extended.
Interim order, if any, is extended till the next date of hearing.
Much of it.
I'm sure was the last of them.
January.
Much of it.
Next.
28. Serial number 28. Lochan. 28. Serial number 28.
Pass over, my lords.
Pass over. We have again called.
Just my lords, senior is voted in.
Call it.
9. Serial number 29.
My lords, I seek for a short accommodation.
Hey, ma'am,
Senior is out of station.
we just call this full list.
So final.
Number 2. Serial number 1.
Just wait.
Srimati Anuradha.
He's out
serial
of,
number 1.
my lords, sorry, he's out of station, my lords, he's not in.
Just say that at the request of counsel for the appellant, on the ground that the arguing counsel is out of station, re-notify.
4th of February. List number 2. Serial number 1. Srimati Anuradha Aras. Appear for that.
Yes, ma'am.
My lords, this is the matter with regard to the calculation of the grant of award please election. In fact, I had addressed my argument on the last
What
occasion.
was your case setup?
Escalation amount calculated by the arbitrator is not proper. That is my contention, please, Your Lordship. That is one of the contention. And the second is interest granted. The interest has not been granted to me. These are the two contentions only, please, Your Lordship. Nothing on merits, please, Your Lordship. Only calculation.
Let's see the award itself.
Yes, please, Your Lordship.
Now what is the error in the computation?
My lords, the calculation was the arbitrary tribunal has allowed my contention, please, Your Lordship, and has granted me the escalation charges. Escalation charges, how it has to be granted, as I've already impressed Your Lordship, page number 28. There is an mentioning as to how it has to be calculated, please, Your Lordship. May Your Lordship get in page 16, page number 28. It starts with para inverted comma 52, please, Your Lordship. May I please, Your Lordship? A sum of rupees 98 lakhs is what it starts. What would be necessary for our consideration is from page line 9, please, Your Lordship. What is argued before this tribunal is that clause number 32 of the tender document provides for escalation in the service fee. It is argued that though the contract period of 3 years came to an end on 15/3/2010, the claimant was asked to continue the work of MSW till 2012, and therefore 5% escalation charges is applicable for the 4th year of the contract also. In this regard, it is better to extract clause number 32 of the tender document marked as exhibit. Clause 32, please, Your Lordship. It is clarified that the bidders would be required to quote the service fee payable by BBMP during the 1st year of the contract period. The service fee would be increased by 5% over the preceding service fee during the next 2 years of the contract period. In an event of extension in the contract period from 3 years to 4 years, BBMP shall pay to the service provider service fee as applicable during the 3rd year of the contract period. There would not be any escalation during the extended contract period. This is the clause, please, Your Lordship. So my submission is the tribunal has granted me $36,75,000 as the escalation charge, please, Your Lordship. That for the 1st year should be added with 5%, will be the second year amount. That again should be added with 5%. That will be the 3rd year amount. That is how I have calculated, please, Your Lordship.
He has not done that.
Pardon, please.
What now? He has given 36,75,000
Yes, please, Your Lordship.
by increasing 5 years.
Together, 30 months, he is calculated as 30 months. I do not know how 30 months came there, please, Your Lordship. When I could cut down that.
The contract is for how many years?
It was for 3 years, please, Your Lordship, plus 1 year.
So now on what basis, so now this 36 lakhs
Yes, please.
is the escalated amount.
Yes, please, Your Lordship.
That's right.
24 lakhs was the amount that had to be paid to me monthly, please, Your Lordship. That calculation I have furnished in the last of the 133 page, 134, please, Your Lordship. There is a little bit of confusion with regard to the page number. That 134 is the page number, please, Your Lordship. Memo of calculation is what I have made my heading.
Yes, show us from this.
Yes,
We are
please.
concerned which period?
From 2008 onwards, please, Your Lordship.
2008 to?
2012, please, Your Lordship. As to how it became after 3 years is there were separate orders passed by the BBMP, wherein that was extended, please, Your Lordship. I will take Your Lordship to as to that aspect, please, Your Lordship.
No, now tell us.
Yes, please.
Where is the abstract? You see the abstract? What is this abstract?
What?
Page 134.
This is my calculation, please, Your Lordship. This is how the calculation should have been, is my submission, please, Your Lordship. The court, the tribunal has granted me overall 30, that is how the court has arrived at, and it has granted me.
How? Show us how the tribunal.
The tribunal has not furnished any calculation, please, Your Lordship. It is.
But have they paid this amount of 36?
It is only order, please, Your Lordship, in the award. Order in the award, please, Your Lordship.
Have they paid that amount?
No, please, Your Lordship. I have challenged that award, so I have not received it.
No, but that's an admitted liability.
Your Lordship, page number 35, please, Your Lordship.
Which 35? 135 or 35?
No, only 35, page number 135, in page 23, please, Your Lordship. Para 16, please, Your Lordship. In view of the finding supra, the claimant has proved that the respondent is in breach of the agreement dated 15/3/2007 in not paying the escalation charges. Consequently, the escalation charges cost at 5% on monthly service fee agreed as per Exhibit P4, that is 24,49,999 per month for the period of 15/3/2010 till 31/08 of 12 works out to be 36,7499 rounded off to 36,75. This is how the calculation, this is all what is mentioned as to how the calculation is arrived, please, Your Lordship. But there is no basis as to how that amount has been arrived, please, Your Lordship. To show that it is not properly
So
calculated.
this escalation is every month.
Yes, please. No, yearly, please. Yearly.
5% on monthly service fee.
Monthly service fee is 24,04,999, please, Your Lordship.
So it's being paid monthly.
That was paid, please, Your Lordship.
So escalation 5% on what?
On 24 for the first year.
Monthly. So that's what we want to know.
Yes, please.
Suppose
That-
January you got 24.
Yes.
The next year would be +5 and then.
Yes, please, Your Lordship. That is
So
how.
high the escalation every month.
No, please, Your Lordship.
That's what.
Your Lordship, my calculation, if Your Lordship sees my calculation. My lord's 34 lakhs, the third column, please, Your Lordship, page 134. 24,04,999 is the amount, please, Your Lordship. 1,22,000 will be the escalation charges, please, Your Lordship.
What are you saying?
134.
Page 134, please, Your Lordship.
Yes.
Third column, please, Your Lordship, is
Yes.
the actual amount that they had to pay. 24,04,999 as agreed, please, Your Lordship, from 2007 to 2008. After that, there should be 5% of increase. That 5% will be per month, 1,22,500, please, Your Lordship. That is a difference amount I have shown in the last column.
How are we getting that 1 lakh?
5% on 24 lakhs, please, Your Lordship.
Where is 24 lakhs?
24,04,999, please, Your Lordship. That is the agreed amount that they had to pay me monthly, please, Your Lordship.
So April 12, so every month there is an increase of 67.
6,76,000 every month. According to you.
1,22,000.
No?
First year, please, Your Lordship.
Yes. No. April 12.
That is the last.
5%, 31,26,888. Bill amount 24,49,999.
Yes, please, Your Lordship.
Difference
That is,
6,76,889.
my lords, the page starts from 134, please,
Yes,
Your
yes,
Lordship.
yes,
It
that
is
paper.
21st March 2008 to 31st/3/2008 is the first entry, please, Your Lordship. The second is April 2008. Your Lordship could get that. It is
Yes,
like
Mr.
this.
Chandra, what do you say?
My lord, firstly, the claimant who is before this court is asking for enhancement on the basis of 2 other awards which has been passed by a different arbitrator. Can there be a parity which is here? There, incidentally, some additional amount has been granted. Here, this arbitrator thought it fit to grant only a certain amount. Can that be a precedent for this claimant to seek in the same way?
Even if it is not, what is her claim is whatever I am entitled to under the contract, I must get it.
If so, my lord, the arbitrator has already decided it. She also filed a section 33 application where he says it is not a matter for correction, and also he reiterates saying that it cannot be again decided on merits. Same has been confirmed by the section 34 court too. And this calculation which is given here is for the first time. It is not found with the section 34 court also.
No, but would not this be an explaining the stand which has already been taken, maybe before the 34th court or before the arbitrator? She says the only way the clause need to be interpreted is in this manner, which the authorities or the 34th court or the arbitrator has overlooked.
Maybe, even if it is overlooked, there has been a finality to it. We are in section 34, we are not on 96.
Right. Suppose for a moment we want to understand from you, if the contract has not been followed by the arbitrator in the manner the clause stipulates, for any claim, for any monetary claim, will she not be entitled to, or he entitled to, the monetary claim in accordance with the contract?
They have given it. The arbitrator has given it. It may be less. It looks less when you compare it with another award, not this award.
No.
So therefore, the parity will it come in question.
No, you can
the
argue this.
arbitrator has been reasonable.
You can
Maybe
argue
this
this.
man does not. This arbitrator is not.
You can
But on
argue
that count,
this.
can he come to the section 37 is my question. And 2 times the same arbitrator under section 33, section 34, both say that this calculation is not there.
We are clear it is not a case of 33. Let's be clear.
Yes.
She is seeking modification of the award, that is not permissible.
Yes. Lordship, kindly observe the order passed by the 33.
Now, come to page 28.
Yes, Lord.
Everything need to be seen from the perspective of the contract. What are the contractual terms? She relies upon clause 32.
Yes, Lord.
Okay. She says it is clarified that the bidders would be required to quote service fee payable by this during the first year of the contract period. The service fee would be increased by 5% over the preceding service fee during the next 2 of the contract period. In an event of extension in the contract period from 3 to 4 years, BABMP shall pay to the service provider service fee as applicable during the 3rd year of the contract period, not by any escalation during the extended period of contract. Now, what she says is, once after first year, there is an escalation, then you would add that 5% of the escalated amount for the second year, and you would pay that escalated amount in the second year. And similarly, for the second year to 3rd year, you would add on to 5% on that amount which was escalated between first and second year, pay it in the 3rd year.
Cumulative.
Submission. Now see what the arbitrator does.
Yes, Lord.
Let's see the arbitrator award.
May I submit, my lord, before going to the short, sorry for that.
Yeah.
Assuming for a moment that the arbitrator has erred, question is, can it be remanded? It means it has to be set aside.
Yeah, that's true. We are right. You're right. That's the right position. You're getting what he's arguing. We'll set aside, send it back to the arbitrator. Correct.
Lordship, kindly see one more provision, my lord. Section 34(4) probably could have been invoked by her, not 34(2).
By the
appellant before this court to be explored before the section 34 court.
No, are you saying it's only 34 court which could have remanded?
Yes.
Not 37?
Not 37.
Tell us one thing, what can be done by 34? Why can't we do it?
My lord, I am only on that, my lord. Section 34, because it says 34(4). This is for again academic reasons. The court may appreciate based on my submissions.
We'll see that. See, 34 doesn't relate to the powers of
37.
us because
Yes,
we are
sir.
exercising under 37.
Yes.
And minded judgments are there. The scope of judicial review would be same parameter to what are the scope in 34. What is the scope under 34?
My lord, my submission is this. If the court under section 34 ought to have been explored, the appellant ought to have explored under 34(4), and instead she doesn't explore and it comes now to the 37, can it be now seen? 34(4) may kindly be seen. On receipt of an application under subsection 1, the court may, where it is appropriate, and it is also so requested by a party, adjourn the proceedings for a period of time taken by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the arbitral award. She should have put it before the 34 court. It would have been otherwise, it will be setting aside. Please don't set aside. Send it for the limited purpose under 34(4). Let him examine again. In fact, I was asking myself, the 34(4) would have been 34(2), 34(2) would have been 34(4) when drafting the section. Because 34(2) speaks about setting aside.
So what you say is under 34(4),
she should have explored it.
The court could have
yes
adjourn the matter
yes
for the arbitrator to look into it.
Yes.
Whatever is the ground for challenge.
Yes. Upon a request made in writing, that is important.
That's fine.
Not just filing 34 application. The requirement is 34(4). A request has to be there in writing by her. That should be, according to the court, a reasonable ground, which otherwise would have been set aside.
But that process was not undertaken.
True. So my question is, when she has not explored that there, can that be done in 37?
Very well. But in any case, it's an appealable order under 37.
True, my lord, but what could not have been done, can it be done now is my only question. It's an academic interest.
She is not canvassing her case based on 34(4). She says very well the 34 court has not exercised properly the jurisdiction.
What has been done is, while determining under 33(2), he says, I have already examined, there is no scope for revision otherwise also. So there too, so it is again a determination to 30 by the tribunal. I read page 42, my lord.
Yes.
The one which starts with the said position on law has been referred to by the learned authorities,
Yes.
Next that. It is also a settled law that a party cannot seek review of their award under the garb of an application to seek interpretation of a specific point or part of the award. Next, in the light of the above order in above position in law, with regard to section 33 of the Act, the prayer made in the application cannot be granted by this tribunal, since a conscious decision was taken by consideration of the record of the case of the rival contentions while passing the aforesaid order. That's the earlier award. So my order under the award is conscious one.
That's
So
right.
it's a reiteration.
Judicial review is still open. This is the view of the arbitrator.
True, my lord. Because that is not the only thing. I mean, it's repeated by her, the arbitrator, saying that I've done it consciously. I'm not taking into two other awards as parity.
Very well. We don't know. We are, insofar as we are concerned, this is the award before us. What have been done in those two awards is irrelevant for us. Now, maybe he has done it based on those two awards, but we are testing this award.
Yes, madam. Because even the section 34 court also says there is no calculation available. So what is the calculation given here was not available to him.
Very well. That's what we have pointed out. Come to page 28.
Yes, madam.
Which reproduces the provision of the contract in what manner escalation need to be given.
Yes.
Now, what is your submission on that?
I have not applied myself because I was only on the technical aspect on the merit, because I don't know the matter which was long back, for 10 years back.
Just look into this 28, 32.
Yes.
clause 32 and what has been done by the arbitrator and read or possibly consider it in consonance with we don't know whether the calculations have been filed are in terms of this interpretation to clause 32. But you would still independently consider what has been said by the arbitrator and what 32 contemplates. Okay. Now, whether that has been done or not, that need to be seen. That's a short issue here.
Yes, sir.
Now you see the arbitration award.
36,75,000 has been awarded.
Now, what is the computation for 36?
Yes, madam. I understand.
There is no computation. Now come to possibly some indication in paragraph 16. What he says is 2 for this 9 per month for the period this till this works out to 36.
Yes, madam.
Rounded off to 36,75,000.
Yes.
So what according to you, ma'am? What according to you, your figure?
It should be.
See, what we are understanding is your submission is this. If on an interpretation of clause 32, first year X amount of 24,9, add on 5% thereof for the second year and continue to pay. Okay. For the second year, that's the higher amount, escalated amount. Similarly, when it comes to second year to third year, on that amount, whatever has been escalated amount for the second year, you add on 5% and then continue to pay for the third year. That's her submission.
I understand. But another aspect, I think we have satisfied this award also.
Very well.
Now the question is to be set aside.
No, satisfied means have you paid to her?
Subject to instructions, I think we have, because there is a batch of 25 petitions.
Did you get it?
No.
She is saying no, she did not.
Because we will not have the award copy, please, Your Lordship. One which is given to us, we will be filing it in the appeal court. Without that, we will not be able to claim also, please.
I'm not sure because there are a batch of 25 cases which were disposed of. We honored all of them is my instruction.
No, you must give the how many cases of similar nature were there?
25.
And all have been satisfied.
Yes, that's my opinion given then, and the instruction was it is satisfied. I do not know about particularly this case. This is one among the 25.
And see, we just want to know what is the basis for him to give this award amount, 36,75,000. What is the basis?
I understand what
has he followed 32? Has he followed 32 or his own computation?
No, I understand. What Lordship is saying is there is application of mind required to this. Only thing is whether having satisfied, if I am satisfied, subject to that, can it be against?
That she is not saying it has been very well. We'll just have it next week, Mr. Chandra, get your instructions.
Yes, madam.
And possibly, very well, just file a note of submission of yours, what happened in those 25. Just say that we have heard the counsel for the appellant and also Mr. Chandra for the respondent at the request of Mr. Chandra, re-notify on.
May I request this to be taken in the main list, madam?
Yeah, it will come to the main list now.
Okay.
Event 1. Serial number 2. Ranjan Kumar.
And just call the password.
Serial number password matter.
Call the counsel. Just 1 minute. You argued, yes, not him. Him.
Ranjan.
You know, yesterday you mentioned that matter. Just call the counsel also.
Yes.
The other side also. So
yes.
You said 18 lakhs. The interest must also be included. Just call the counsel so that you can mention it before him. He should be in the knowledge.
Yes.
Okay, just call him today after lunch, possibly.
Yes.
Mention it.
Yes. Okay.
Password matter 28.
Yes.
Number 10 submission. Serial number 10, my lord, first list. Withdrawn the matter, my lord. Kindly refund the court fee. Kindly refund it.
File an application. We'll look into that. Just pause memo. Where is that? No memo, no.
Give me, this can come later. Give me the paper book.
System.
in the execution petition, my lord, joint memo filed, we have paid 7 crores to the respondents. My lord. Now joint memo filed in the execution petition. Now, my lord, appeal is impossible. Kindly refund the court. My lord.
The item 11.
10.
Just show us the file. Just wait. Come at 2:30.
My lord.
Yes.
Apologies, my lord. It's possible.
It's all right. Yes.
Section 37, appeal by the successful claimant before the tribunal. The award was in my favor. Section 34 court has intervened and set aside the award. That intervention is not justified is the case that I'm going to make out before this honorable court. Now, the documents may be relevant, but I filed a set of documents on 10th September, compilation of documents. Yes, that. Pick one, yes. Paper book.
These are all part of the
Part of the record. All exhibits marked and part of the record. Just briefly, my lord, the context before I begin with the submissions. The context is like this. The project that was handed over to the respondent was collection of data for Aadhaar card preparation, National Population Register. So the government, the concerned ministries had floated tenders for various districts across the country, saying that in these districts, data collection needs to be done for preparing the NPR and for Aadhaar card compilations. Respondent was one such successful tender for certain districts. Respondent subcontracted the work to the appellant here. He was a successful tender. He was the interface with the government. He subcontracted the work to me. I discharged the work, rightly, wrongly, whatever. We had differences of opinion as far as the payment to me was concerned. So we had differences. We entered into a settlement agreement saying that as and when you receive the money from the government agency is called NILET. There is the full form can be seen. The government department, as and when you receive money from the government department, 5 crores you will pay to me in this manner. And whatever money you receive, we will also distribute it amongst us proportionately.
Amongst ourselves mean the appellants.
Pardon?
Amongst ourselves mean they will get 5 crores for the whole work.
No, they will get whatever they get from the government.
Yeah.
So long as it's above 5 crores, I will get 5 crores. If they get 7, for example, they can retain the extra 2. But I will get 5. That is a settlement that we are at. We also agreed to open an escrow account, saying that as and when the government department gives something, you will put it in the escrow so that from the escrow, we will get it as we have agreed in the settlement agreement. That escrow account was also opened. What happened was they received the money. They diverted it from the escrow account and took the money completely on their own. That has been confirmed by the government department also. I was left with no choice. I initiate arbitration proceedings. I come before the tribunal. I say there's not much of a dispute. There's a settlement agreement. The settlement agreement says that this is the acknowledged liability. They have acknowledged how much they have to pay me.
The arbitration clause was?
The arbitration clause was for arbitration before a domestic arbitrator, sole arbitrator.
The main contract.
The main contract in the settlement agreement between us. So it does not involve the government department because there's no dispute with the department.
No, it was in the set. No, there must be some earlier agreement between them, principally after the work was given to him.
Correct.
Then it was given to you, subcontract.
That's right.
There must be an agreement.
Then there is a settlement.
So the arbitration was there?
In the settlement agreement.
In the settlement.
In the settlement agreement, there is a specific arbitration clause where we agreed that he will pay me so much. That settlement agreement has been breached. I come before the learned arbitrator. The arbitrator says, what is there to discuss? Are you disputing the settlement agreement? He says, no, I'm not disputing the settlement agreement. The contention is raised, which my learned friend will of course try to make good, is that the settlement amount was subject to imposition of penalties the government department having imposed penalties, I am no longer required to make payment to the appellant. Therefore, the arbitrator squarely issued the issue if penalties have been imposed. Bring proof. The finding of fact by the learned arbitrator is there is no proof that penalties were imposed. Penalties were threatened. Penalties have not been imposed. Therefore, the learned arbitrator says
penalty would be imposed on them.
On them. And to that extent, this
Fortunately would get affected. You get affected.
That's right. That is a settlement agreement. There is no dispute on the terms of the settlement agreement. Therefore, it was incumbent upon them to show that they have suffered penalties to an extent of whatever amount. That evidence has not been led on a finding of fact. The learned arbitrator holds the penalties have not been imposed. If the penalties have not been imposed, whatever is agreed, whatever amount has come has to be distributed in accordance with the proportions that we have agreed. Therefore, the learned arbitrator does exactly that. He says, this is the proportion you have agreed in the tribunal, in the settlement agreement. Therefore, you get to retain some amount, you got to pay some amount. The Section 34 court, impressed with their argument of penalty, says that that has not been looked into properly, and the distribution that has been done. We had two settlement agreements. I'll take my lords through that. The distribution that has been done is not done appropriately in terms of the contract, reinterprets the contract and says the learned arbitrator has committed an error, which is not within the jurisdiction of the Section 34 court, is my submission. The Section 34 court could not have supplanted its own view on its understanding of the contract, where the learned arbitrator has already applied its mind, the tribunal has applied its mind.
When two views are possible.
When two views are possible, he does not say that that view is incorrect. He merely says this is the correct view. Maybe this may be one view, but the view of the arbitrator is
Let's
not.
see that finding.
Where? The finding itself, my lord?
Yeah, 34.
Of the Section 34 court?
Let's see 34, the arbitrator's view.
Where?
On insofar as the settlement is concerned, not disputed.
Not disputed.
Insofar as the penalty sought to have been imposed, not proved.
That not proved.
And he granted.
That's
Now, what is the interpretation? Which was the clause which was sought to be interpreted by 34 court? What is that clause? In what manner he has interpreted? And what manner even the arbitrator has interpreted?
Before I take my lords, just two documents, the settlement agreements, can we take a look at it? How plain they are, how obvious they are. But in the paper book that I have submitted, in page 12, we are still trying to endeavor to ensure that everything is electronic filing. This time we were not able to do, but I'm aware of this court's desire that we should move to electronic filing. I will do it.
We are in the middle of the Silicon Valley. We should be at the forefront.
This Christmas vacation, that is one of the to-do lists, that everything needs to be online and everything must be filed electronically.
And at least talking of the senior councils and other councils, at least they should not bring physical copies.
I hope that this will be one of the last matters that I get to argue with my lord with paper copies.
It's not a mandamus, huh?
No, not at all. But we should all move towards that. We should move towards that. Yes.
One must move.
Yes. It's just that the younger people find it easier to adapt to technologies. At our age, just a bit of a challenge. But then my lord is an inspiration.
Don't say that. Yeah. Talking about me, I was not so tech savvy.
It was a challenge.
It's not tech savvy at all. Old school.
That's right.
COVID.
I think yes.
COVID in Delhi, everything was, you had to operate from home. The physical files were not coming.
Correct.
Everything was.
I had no choice but to learn.
That really.
That's.
And I found it, you know why? When there were physical files pre-COVID, I was in the original side, all those IPR matters, everything.
Correct. Voluminous.
Volumes, 7788, backs used to come. So my people at home, they were in the big. I said, yeah, at least for him, I should stop. And now I started getting pen drive for all.
Excellent.
So that's the easy.
Excellent. Really. So this was a bit embarrassing that my lord is having to look at paper books. Next time on will be careful. This time. Page 12 is the settlement agreement. This is dated 2nd September 2014. At ink page 14, my lord, clause 5. By virtue of the settlement arrived at between the parties herein, Shrivan, that is the respondent, agrees to pay to Emphasis, that is the appellant, an amount of rupees 5 crores towards full and final settlement of accounts between the parties against the execution of data digitalization project and NPR, National Population Register, as and when Shrivan gets paid by the National Institute of Electronics and Information Technology, that is NIELIT, against the services rendered by emphasis. I have provided the services, the government department will pay them. As and when they receive the money, they will pay me 5 lakhs. In the event any penalties are imposed by NILIT related to the project rendered by emphasis, emphasis shall be liable against such penalty, and the settlement amounts as stated in clause number 5 above stands reduced by that extent. Both parties agree to work with concerned officials to ensure that there are no penalties imposed on emphasis. Now to the next page, clause 9. Shrivan and emphasis will enter into escrow account with a mutually agreed bank, and Shrivan shall ensure the said escrow bank account is recorded with NILIT so as to ensure the amount payable from NILIT is released only to the escrow account. Shrivan agrees to share the acknowledgement from NILIT, consenting to and recording the change in the bank account. Now, clause 12, how the amount is to be distributed.
Till this date, there was no representation from their side that there is a penalty imposed.
No.
Nothing.
As on this date, no. In fact, the learned arbitrator makes note of that. That if prior to this date already penalties were imposed, that would have been reflected in the settlement agreement. So as on the date when the settlement agreement was entered into, penalties were not imposed because that is evident from the reading of the document itself. Clause 12 on page 15. Entire balance amount release against clause 11. Against the further release of amount by NILIT, Shrivan shall be entitled to 60% of the amount of the payment up to a limit of 2 crores. Entire balance amount released by NILIT shall be paid to emphasis. The first 100%, 2 crores will go to Shrivan. Then the next up to 2 crores will be divided between Shrivan and emphasis 60-40, and the balance will come to emphasis 100%. This was done in the first settlement agreement. At page 26, my lord, this settlement agreement was modified. At page 26. At page 28, the modification. Clause 10, where, my lord, we had said that the amount will be distributed in this manner.
Which clause?
Page 28, clauses 10, 11, and 12, where that illustration that I read out, 100% will shift here, there, that came to be modified. Initial remittances of amounts up to 57,45,000 from NILIT shall be paid to emphasis entirely from the escrow account. Subsequent remittances of amounts up to the extent of rupees 2 crores by NILIT shall be disbursed entirely to Shrivan from the above escrow account so as to enable Shrivan to pay and close the accounts with sub-vendors and to ensure that there are no future liabilities on emphasis. Well, this clause becomes important because this is where the section 34 court thought it fit to interfere. It was agreed that 2 crores will be paid to them for the purpose of distribution to sub-vendors and other liabilities.
What sub-vendors?
My sub-vendors. That they will pay those liabilities. Therefore, 2 crores will go to them. But in the course of evidence, it was established that there were no such sub-vendor liabilities. So the learned arbitrator thought it fit to give the 2 crores to me, saying that anyway, you are also entitled to it, so that 2 crores will come to me. Section 34 court says, no, it should have gone to them only because that is what is agreed. But the learned arbitrator applied its mind, the tribunal applied its mind and said it was supposed to be going to them for the purpose of discharging sub-vendor liabilities. If there are no sub-vendor liabilities, why should that amount go to them? It should come to me. That is the interpretation that the learned arbitrator put.
This 2 crores would be an amount beyond 5 crores.
No, everything within
5.
Not for a moment does the appellant make out a claim.
Clause was not there in the earlier
Agreement. This was not.
Yes, read this clause.
Hello. Initial remittance of amounts up to extent of 57,45,000 from NILIT shall be paid to emphasis entirely from escrow account. Subsequent remittance of amounts up to the extent of 2 crores by NILIT shall be disbursed entirely to Shrivan from the above escrow account so as to enable Shrivan to pay and close the accounts with sub-vendors and to ensure that there are no future liabilities on emphasis in this regard. Shrivan agrees hereby to disburse payments to sub-vendors within 60 days of the withdrawal of the money from the escrow account. Shrivan further agrees to maintain appropriate receipts, records, vouchers, bank statements, bills, photocopies of checks, demand drafts, registers, and such other financial and other documents as may be necessary to evidence payment and full and final settlement of dues to various sub-vendors for a period of 5 years from the date of each such payment.
Let's assume you were to get the 5 crores.
That's it.
You would have still paid the sub-vendors?
No, it was always their liability.
So always their liability.
It was always their liability. It was now decided that from the money that is coming,
you could then then if that's be so, then against those 5 crores, that 2 crores need to have been adjusted.
That's provided those liabilities existed.
Right. But does the earlier agreement says 5 crores, there is a liability towards sub-vendors? Doesn't say so.
The reference to sub-vendor liabilities does not come up at all, except now for the first time.
So that means complete amount of 5 crores to be given, 2 crores sub-vendors would be given by them.
By them.
But is there any stipulation in the earlier agreement for sub-vendors?
No. We can just go back to the initial agreement, my lord. It's at ink page 12. The agreement begins, the first agreement begins at ink page 14. We'll quickly just skim through the various clauses. Page 14. Clause 1. There were certain business transactions between the parties pursuant to memorandum of understanding dated so and so, consequent to which emphasis had rendered certain services as detailed herein. Shrivan also provided certain services for which it is entitled to adjust payments payable to emphasis. Certain disputes arose between the parties as to the volumes executed by emphasis, and certain notices got issued against each other, making claims and counterclaims. Emphasis also preferred a criminal complaint against Shrivan and its directors under section 138 of the Negotiable Instruments Act, dishonor of check, in the court of so and so. By virtue of the settlement arrived at between the parties herein, Shrivan agrees to pay to emphasis an amount of rupees 5 crores towards full and final settlement of accounts between the parties against the execution of the data digitalization project and NPR2, as and when Shrivan gets paid by National Institute of Electronics and Information Technology against the services rendered by emphasis. In the event any penalties are imposed by NELIT related to the project rendered by emphasis, emphasis shall be liable against such penalty, and the settlement amounts as stated in clause number 5 above stands reduced by that extent. Both parties agree to work with concerned officials to ensure that there are no penalties imposed on emphasis. This agreement is entered into after taking into consideration the efforts put in by Shrivan, and Shrivan shall not be entitled for any claims, benefits, etc., either from emphasis or its directors, employees, etc., and undertakes to pursue the matter with NELIT to get the payments released as soon as possible for the efforts put in by emphasis and pay to emphasis as stated herein below. Shrivan also agrees to provide proof of paying 33,40,000 to 99 Infrastructure, that's the name of a company, on behalf of Messrs. 3K towards EMD repayment, which initially was issued by emphasis. The balance EMD of 57,45,000 refundable by Shrivan to emphasis is adjusted in the amount payable to emphasis as stated herein as full and final settlement of accounts between the parties. All the obligations, responsibilities as agreed under the MOU dated so and so and the minutes of meeting held so and so shall continue to be binding upon respective parties till such time the total payment being the entitlement of emphasis is paid to emphasis in pursuance of the settlement terms as agreed between the parties. Shrivan and emphasis will enter into escrow account with a mutually agreed bank, and Shrivan shall ensure the said escrow bank account is recorded with NELIT so as to ensure the payment payable from NELIT is released only to the escrow account. Shrivan agrees to share the acknowledgement from NELIT, consenting to and recording the change in bank account. The initial release of 2 crores by NELIT would be disbursed entirely to Shrivan from the above escrow account so as to enable Shrivan to pay and close the account with sub-vendors and ensure that there is no future liability. I stand corrected, Mala. This is the clause that was there. The initial release of 2 crores by NELIT would be disbursed entirely to Shrivan from the above escrow account so as to enable Shrivan to pay and close the accounts with sub-vendors and ensure that there is no future liabilities on emphasis in this regard. Against the future release of amount by NELIT, Shrivan shall be entitled to 60% and payment up to a limit of 2 crores. Entire balance amount released by NELIT shall be paid to emphasis. It is specifically agreed that on Shrivan paying the betterment amount, the settlement amount as agreed herein, emphasis shall not have any further claims against Shrivan and emphasis shall withdraw.
57 lakhs would go to emphasis.
Yes, ma'am.
Then the liability is over. See, what was amended was 10, 11, 12.
That what was amended was 10, 11, 12. The extent of amendment was this. In 10 earlier, it merely said you will get the first 2 crores to settle the liabilities. The amendment casts an onus on them to bring evidence to that effect. The amendment cast an onus on them to bring evidence to the effect that such settlement has taken place. The arbitrator notices that and says there is no such evidence.
Then see, if you see the page 15.
Yes, ma'am.
Clause
10.
Even also agree to provide proof paying this district infrastructure on behalf of TK towards the payment, which enable the balance EMD of 50% refundable by Shrivan to emphasis is adjusted in the amount payable to emphasis as stated herein and full and final settlement.
That is as far as EMD is concerned. We are that is clause 7. We are concerned with clause 10.
That's right. So 2 crores was to come to you.
No.
In terms of 10
No, in terms of 10, 2 crores was required to go to them.
would be disbursed entirely to, okay.
To Shrivan.
Account. Okay.
For the purpose of meeting sub-vendors' liabilities. This first agreement was silent only up to this extent. The amendment that was brought about at ink page 28, while we hold on to 15, if I may persuade my lords to come to page 28, the amendment cast a burden on them to also establish the existence of such sub-vendor liabilities and to prove that they have been paid. Initial remittance of amounts up to extent of 57 lakhs, that is at EMD portion, my lord, from NILET shall be paid to emphasis entirely from the escrow account. Subsequent remittance of amounts up to the extent of 2 crores by NILET shall be disbursed entirely to Shrivan from the above escrow account so as to enable Shrivan to pay and close accounts with sub-vendors and to ensure that there are no future liabilities or emphasis in this regard. This is the same clause that was there in the earlier clause. Shrivan further agrees to maintain appropriate receipts, records, vouchers, bank statements, bills, photocopies of checks, demand drafts, registers, and such other financial and other documents as may be necessary to evidence payment and full and final settlement of dues to various sub-vendors for a period of 5 years from the date of each such payment. This is the amendment that was brought. What the learned arbitrator has held is there is no such evidence. The amount needs to be distributed. So to the extent of 60-40. Continue the distribution. Let the amount come to emphasis to the extent of 60%, 40% to you. The eventual award also does not blanket give me a sum of 5 crores. In fact, the award is not even for 5 crores. It is for an amount less than 5 crores to me and the balance to them. Because the amount that came to be released from NILET eventually is approximately 6 crores 47 lakhs. I have the number with me. 6 crores 47 lakhs. So out of 6 crores 47 lakhs, done 5 crores to emphasis is not what the learned arbitrator said. No. There is still a percentage, there is still a proportion that has been agreed to by you people. I will still follow that same proportion and give the money according to the proportion. If emphasis falls short of 5 crores on account of that proportion, too bad. You will get less than.
What is the proportion?
That is given here.
60-40.
60-40. It's given here. At ink page 28.
What is emphasis?
The initial 100% to emphasis. Thereafter, the next 2 crores to Shrivan and then 60-40. So he says, anyway, you have agreed on 60-40. The first amount of 57 lakhs goes to emphasis. Thereafter, there is no evidence of sub-vendor liabilities. Distributed 60-40. And he's given it exactly on those terms, 60-40. The section 34 court says, no. What you have agreed in the settlement agreement, the amendment to the settlement agreement is 2 crores goes to them. What the section 34 loses sight of is that 2 crores goes to them provided there are liabilities and that 2 crores has been expended to meet those liabilities. It does not go into their pocket. It is not their money to be kept for themselves. It is to be utilized for payment to sub-vendors. That they did not bring any evidence.
In terms of amended 10.
Amended 10 at page 28. Because it is what money comes to me is mine. I can spend it the way I want. What money goes to them, the 2 crores, is not theirs. It is to be utilized for sub-vendor liabilities. Those liabilities, the learned arbitrator said, I will give it to you. The money is there. I will give it to you. Show me that there are sub-vendor liabilities. They were not able to do so. So the tribunal renders a finding of fact saying that there are no sub-vendor liabilities which you are able to demonstrate. Therefore, follow what you have already agreed, 60-40, distribute it amongst themselves, between yourselves. This is an interpretation of contract. That is how the contract has been interpreted. This is a possible view. It is not a view that shocks the conscience of this court. How is this even possible? The learned arbitrator has gone beyond the terms of the contract. He is misconducted himself. If that is the view that the section 34 court had taken, that's a different matter. The section 34 court does not say that this view is incorrect. He merely says, no. What the arbitrator may have done is there, but this is what you guys have agreed. Therefore, 2 crores must go to him. The learned arbitrator, not having done so, has committed an error in not following the terms of the contract, and therefore the award is bad. Very well. A lot. Just to show how the parties conducted themselves pursuant to these agreements, because there is also very huge malafide on their part. I'll just demonstrate those malafide and then come to the award. At ink page 18, parties had agreed that we will open an escrow account. The parties jointly write to ICICI Bank saying that please open this escrow account. And we also set out the proportions and percentages. Then, my lord, at ink page 24, the respondent writes to the government department, informing the government department also of the existence of the escrow account, and says, please, as and when you release monies to, on account of this project, you ought to release it only into this escrow account. At ink page 25, we once again reiterated jointly, both of us write to the government department at ink page 25. All these are exhibits that are marked in evidence. At ink page 25, both of us write. Then, my lord, at ink page 31, we inform the bank of the revised understanding between us 60-40 regarding the escrow. I had also initiated a criminal complaint which I had agreed that I will withdraw. That section 131 check they had issued to me. That I withdraw at ink page 38. I abide by the terms of the settlement. At ink page 38, I report to the learned magistrate that under 257 we are compromised and therefore I wish to withdraw. The section 138 complaint is closed. I don't hear from them for quite some time. This all happened in 2017. Therefore, at ink page 39, I write to the government department saying, look here, I have not heard from you for quite some time now. I hope everything is okay. I am just reminding you that the amount that you will be disbursing must come into that escrow account, and I reiterate the factum of that escrow account at ink page 39. I still don't hear from them. The government department does not respond to me because I have no privity of contract with the government department. Therefore, they don't care to respond to me. I get suspicious, and at ink page 43, I issue notice of arbitration. Ink page 43, they receive the notice for arbitration, but they don't respond. And this is where the cat comes out of the bag. At ink page 47, the government department finally responds to me saying, oops, we released the money. It has not gone into the escrow account. You have given it directly to the respondent. 6 crores 17 lakhs 43,853. This money does not come into the escrow account. The respondent takes it separately and directly. Therefore, the amount available for distribution, my lord, this is the figure, 6 crores 17 lakhs 43,853. How do we get that? Well, my lord, that amount is at ink page 48, where the government department says, this is the voucher, this is the slip. So this is the amount now available for distribution between the two of us. My lord, I initiate proceedings under section 11 at ink page 49. The tribunal comes to be constituted. And we come before the learned arbitrator. My case before the learned arbitrator is simple. There is a settlement agreement that has to be implemented. I have no further case, no further evidence also. These are the two agreements. These are the two agreements I've already agreed. There is no dispute. There is no questioning that settlement agreement. There is no prayer also for saying that the settlement agreement is not binding. Their objections, my lord, at ink page 60 in that same paper book, 60. So, my lord, as time goes by and levels of litigation rise and ingenuity of lawyers also improves, the pleadings change, the arguments change. But this was their first defense, and that is what will have to be looked at. That when the award was being sought, what was the first defense that they raised? At ink page 60 is their statement of objections. Well, at ink page 63, they categorically urge before the learned arbitrator, penalties have been imposed. At ink page 63. Primarily, this is their only defense. That the amount payable to emphasis is not due because penalties have been imposed. They don't quantify the amounts. At ink page 63, para 9 and para 10, in bold black letters. They say it is submitted that since there was default and defects in the execution of the contract by the claimant resulting in levy of huge penalties and additional costs for taking over back the project and to complete the job by the respondent, the amount of 57 lakhs paid by the claimant towards refund of bank guarantee was without choice utilized in implementation of the project only, and as such, the amounts could not be repaid at that particular point in time. It is submitted that as a result of breach of MOU and delivery obligations of the contract by the claimant, the reputation of the respondent was tarnished before NILIT, and the respondent herein received notices repeatedly from NILIT and incurred huge penalties. A copy of the penalty letter is produced here with as so on, so on. So the learned arbitrator goes to that. They also raise a counterclaim at ink page 65, contending that apart from that 6 crores that they have received from the government department, they have suffered a further loss of 60 lakhs, and that also emphasis is liable to make good to them. This is the counter. This was the set of documents that was there before the learned arbitrator. Now, my lord, if I may bring my lords to the award itself. My lord, in the award, the issues are framed at page. My lord is looking at the internal page 35. Yes, madam. Internal page 15 of the award, para 32. Yes. My lord, may I now request my lord to take the appeal memo. In that the page numbers will match. The appeal memorandum, in that the award and the section 34 court award. So there, my lord, the award begins at ink page 62.
Yes.
Yes. And at ink page 76 are the issues. Fairly lengthy, my lord, but just to demonstrate what was going through the learned arbitrator's mind, whether the claimant proves that under the settlement agreement dated 2nd September so and supplemental agreement dated so and of 16 is entitled to a claim of 5 crores towards full and fine settlement, whether the claimants prove that the respondent divorce of the agreed terms on settlement dated so and 2014 and 16 got credited an amount of 6 crores 17 lakhs into his account contrary to the escrow account opened jointly in the name of respondent and claimant in ICICI Bank, whether the claimant proves that the respondent did not inform the receipt of 6 crores 17 lakhs and defrauded the claimant, whether the claimants prove, irrespective of the mode of payment stipulated at clause 12 of settlement agreement and the supplementary agreement to 2016, claimant is entitled for 5 crores as full and final settlement, whether the claimants prove that there is a breach of contract by the respondents by not fulfilling his part of the obligations under the settlement agreement of 2014 and 16, whether the claimants prove that he is entitled for cost of this arbitration proceedings and interest at the rate of 18% per annum, whether the respondent proves that the settlement agreement of 2014 and 16 are unenforceable as per clause 3.7 of the main agreement entered into between respondent and the government of India, whether the respondent proves that the claim of claimant is not maintainable in law in terms of MSP agreements signed between respondent and NILIT, whether the respondent proves that the claimant miserably failed in the delivery of the project and thereby it received many notices with the threat of blacklisting the respondent with heavy penalty, whether the respondent proves that the claimant could not even hand over 20% of the data which it has executed and the respondent had to completely redo data entry and complete the project at its own cost and resources, whether the respondent proves that the claimant filed a criminal case in so-and-so for offense punishable under 138 of the Negotiable Disputes Act to force the respondent to enter into a settlement agreement dated to 2014, whether the respondent proves that due to default and defects in the execution of the contract by the claimant resulted in levy of huge penalties and additional costs in taking over the project to complete the job by the respondent, the amount of 57 lakhs 45,000 paid by the claimant towards the refund of bank guarantee was without choice utilized in implementation of the project only, and such amount could not be repaid at that particular point in time, whether the respondent proves that it was forced to enter into an amendment agreement to the settlement agreement with the claimant as the claimant had not honored the terms of the earlier settlement by withdrawing the criminal case, whether the respondent proves that there was inordinate delay in realizing the amount from the government was only due to the failure of the claimant. Going by the pleadings, the learned arbitrator shows that he is aware of what were the respective contentions of the two parties. That at ink page 88, para 54, ink page 88, para 54. He discusses everything in the previous paragraphs. And then this tribunal framed several issues. However, the issues A, D, E, F, G relate to the settlement agreement, that is Exhibit P1 and P5. Two agreements, my lord, 2014 and 2016. I am at ink page 88, para 54.
Yes.
This arbitral tribunal framed several issues. However, the issues A, D, E, F, and G relate to the settlement agreement P1 and P5. Hence, these issues were taken up together for consideration. From the evidence led by both the parties as well as the rival contentions, it is not in dispute that both the respondent and the claimant entered into settlement agreement on 2/9/2014 and amended settlement agreement on 16/11/2016. In the defense statement, nowhere the respondent disputes Exhibit P1 and P5. Further, by order of the Honorable High Court of Karnataka dated 8/2/2019, produced as Exhibit P14, this arbitral tribunal is constituted in terms of clause 15 of Exhibit P1, and thereby the Honorable High Court of Karnataka referred the dispute for resolution by the arbitral tribunal arising between the parties under the terms of contract Exhibit P1. From clause 15 of Exhibit P1, it is clear that any controversy or claim arising out of or relating to the agreement or performing or interpreting of the same shall be settled by arbitration under the provisions of the Arbitration and Conciliation Act 1996, notwithstanding the terms of an MOU dated 3rd November 2011, that is Exhibit R1. This was some MOU predating the settlement agreement. So the learned arbitrator says, prior to the settlement agreement, nothing matters. Thus, this tribunal is required to resolve the dispute arising out of the terms of the contract in Exhibit P1. As far as issue number A is concerned, the claimant is required to prove that under P1 and P5, it is entitled for claim amount of 5 crores towards full and final settlement of the claims between the claimant and respondent. It is useful to refer to clauses 5 of Exhibit P1, which reads as under. My lord, the learned arbitrator extracts the clauses, and then at page, after going through all the terms of the contract, my lord, at page 104, the learned arbitrator draws its conclusions. Para 78. Ink page 104, internal page 43 of the award, para 78. 78 to 81, my lord, if I am permitted to read. Clause 7, subclause 5 of the settlement agreement Exhibit P1 categorically makes it clear that the claimant had executed the data digitization project and NPR2 NEELIT project, and the respondent settled the said claim by agreeing to pay to the claimant 5 crores towards full and final settlement of accounts. However, the said payment would be as and when respondent gets the same from NEELIT against the services rendered by emphasis. Thus, under this clause, the liability of 5 crores is admitted by the respondent. However, only in case of any penalties are imposed by NEELIT relating to the project rendered by the claimant, claimant shall be liable against such penalty, and settlement amount as stated in clause 7, subsection 5, stands reduced by that extent. Clauses 7, 5, and 6 both together make it clear that 5 crores is the settlement amount, and any reduction in the same would be towards penalties, if any, levied by NEELIT in relation to the project rendered by the claimant. The entire evidence led by the parties do not show that NEELIT has imposed any penalty in respect of or in relation to the project rendered by the claimant, nor is there any evidence that the parties had made any efforts to ensure no penalty is levied on the claimant. When there is no evidence of levy of any penalty relating to the project rendered by the claimant, reduction of any penalty under clauses 7, 5 of Exhibit P1 also does not arise. This is a finding of fact, my lord, by that learned arbitrator. The evidence led, and then, my lord, if we can come to, in fact, he records also the evidence led by the respondent itself shows that Exhibit R4 and R5, which refers to certain proposed actions by NEELIT, are prior to the date of settlement. Thus, when the settlement agreements Exhibit P1 is entered into, parties were aware of all the transactions with NEELIT, and having not mentioned any penalty alleged to have been imposed and in the absence of any evidence of levy of penalty against execution of project work by the claimant, now the respondent cannot say that NEELIT has levied the penalty, nor is it relevant for the disposal of the dispute. In turn, as per clause 7.7, the respondent is precluded to make any claim against the claimant or its director or employee, and in turn, it would make effort to get early release of the payment by NEELIT. From clause 7, it is clear that the claimant is entitled for 5 crores towards full and final settlement out of the payment received by the respondent from NEELIT towards the project rendered by the claimant. It is in consonance with the terms of clause 7 of the settlement agreement, and to ensure that both the parties be kept aware of the receipt of payment from NEELIT towards the project work. they agreed to open joint escrow account as per clause 9. Clauses 10, 11, and 12 relate to this, my lord, as far as the penalty is concerned. The learned arbitrator says there is no evidence. And what you are referring to as exhibit R4 and R5 predate the settlement agreement. It was a threat that, look, you are not doing your job, you may consider imposing penalties. By the time you guys entered into a settlement agreement, penalty had not yet been imposed. You are not bringing any evidence to show that penalty has in fact been imposed even subsequently. Therefore, there is no reduction in the amount at least on account of penalties. Now we come to the distribution of the funds. Clauses 10, 11, and 12 relate to the utilization of the amount so received from NILIT. The initial 2 crores would be disbursed to the respondent only for the purpose of closing the accounts with the sub-vendors to ensure that there are no future liabilities on the claimant in this regard. Clauses 10 and 13 put an embargo on the respondent of the utilization of the amount, that is an initial payment of 2 crores, which needs to be used only to close the accounts with the sub-vendors and not for utilization by the respondent toward its own purpose. That amount of 2 crores was for a particular purpose. It is clear from Exhibit P1 that the claimant is entitled for 5 crores, and in the event if there are any payments due towards the subcontracts, such amount needs to be disbursed by the respondent out of the initial 2 crores in order to prevent future liability on the claimant towards the claim of sub-vendors. Thus, this 2 crores is mainly meant for discharging the liability of sub-vendors, if any, against the claimant. Clause 10 of Exhibit P1 does not refer to utilization of amount by the respondent either towards his claim or his liability to third person, but it was only for avoiding future liability of the claimant. The respondent was authorized to use only for discharge of sub-vendor's liability and not for any other purpose. To protect me, he was supposed to use the 2 crores. The evidence produced by the respondent do not show that the initial 2 crores is utilized towards the disbursement of the liability of sub-vendors. In turn, RW1 in his cross-examination admits, I have not produced any document to show that the respondent owes payment to sub-vendors. In the light of this, the learned arbitrator says, then the 2 crores will not go into that stream of only to you. It will fall into this stream of 60/40. Hence, it can safely be held that the initial release of 2 crores was not paid to any sub-vendor, nor there is any evidence to show that there was any claim from sub-vendors against the claimant. Hence, in the absence of any evidence of payment towards the liability of sub-vendors, this amount mainly meant for avoiding future liability of the claimant towards such sub-vendors. This amount needs to go to the claimant, which otherwise claimant would have become liable to such sub-vendors. Purpose of clause 10 of Exhibit P1 was to make claimant free from any future liability, which is also clear from 7.7 of Exhibit P1. Hence, in the absence of any evidence of payment toward the claim of sub-vendors, the said amount becomes part of claim of rupees 5 crores. Terms of settlement agreement and amended settlement agreement shows that the claimant is entitled for refundable amount of 57,45,000, which is to be adjusted out of 5 crores for which the claimant is entitled. Thus, the initial amount of 2 crores and 57,45,000 would need to go to the account of the claimant, and the claimant would be entitled to 2 crores 57,45,000. Under clause 11, next 2 crores would be shared between the respondent and the claimant at the rate of 60/40. Under this clause, next 2 crores needs to be shared at 1 crore 20 lakhs to the respondent and 80 lakhs to the claimant. More to them, less to me. Under clause 12, future payments made by NILIT would completely be paid to the claimant. Though contention is raised by the claimant that clauses 10, 11, and 12 are not applicable because of the breach of the terms of clause of the settlement agreement by the respondent, and also the said clauses 10 and 11, 12 being subsequent to clause 7.5, clause 7.5 would prevail in clause 10 and 12. When contract is to be interpreted, it has to be interpreted in its entirety, and the dispute which is referred in terms of clause 15 of Exhibit P1 makes it clear that the controversy or claim arising out of or relating to the settlement agreement based on performing and interpreting the settlement agreement. Hence, it cannot be said that some clauses of settlement agreement are applicable and some are not applicable, nor it could be said that the former will prevail over the later. Hence, the claimant cannot claim that the mode of utilization prescribed under 10 to 12 could be ignored or held as not applicable. Because I attempted to persuade the tribunal that look at their conduct, they are mala fide, they diverted the full amount. So full 5 crores are give to me only. I learned arbitrator says I am bound by the terms of the contract. You have only agreed to the terms of the contract. Contract requires distribution in a particular rainfall. It has to, in a particular waterfall. It has to fall in a particular manner. I will abide by the terms of the contract. It is not in dispute that as per Exhibit P13, the respondent has received 6 crores 17 lakhs 43,853. Thus, as per clause 5, though claimant is entitled for 5 crores, but the said payment needs to be worked out in terms of clauses 10, 11 and 12 of Exhibit P1 as held above. Since the respondent failed to prove 2 crores under clause 10 was utilized towards payment of sub-vendors, even otherwise also the claimant becomes entitled for the said 2 crores as part of its claim of 5 crores. Thus the claimant is entitled as under clause 10, 2 crores which is not disbursed to the sub-vendors by the respondent, 57,45,000 as per Exhibit P5, and under clause 11, claimant would be entitled for 80 lakhs and the respondent would be entitled for 1 crore 20. Under clause 12, claimant is entitled for the remaining amount of the remaining amount out of the amount received so far by the respondent from kneeling. Thus, the claimant is entitled for the following amount as under P1: 2 crores, then 57 lakhs 45,000, then 80 lakhs under clause 11, 1 crore 59 lakhs under clause 12. I end up falling short of 5 crores, 4 crores 97. I say, all right, I'm not challenging the award. The claimant would be entitled to the amount out of the claim of 5 crores, and for the balance, the claimant is entitled to recover the same from the respondent. Claim of the claimant for 3 crores 77 lakhs. I had raised a claim for damages, my lord. There is no evidence that the claimant has made any claim of 8 crores except an averment in the claimant petition. As such, it is difficult to believe that the claimant is entitled for the said amount with interest. Since the claimant has proved that the respondent committed the breach of the terms of the settlement agreement, Exhibit P1, and amended settlement agreement P5, it is entitled for the interest at the rate of 18% from 31 January 2018 till payment. From these proceedings, it is clear that the respondent has dragged the claimant for arbitration and made him to incur costs and time. Thus, the claimant is entitled to recover the entire cost of the arbitration proceedings as well as 5 crores towards damages, or 5 lakhs towards damages. Since the respondent has failed to prove its entitlement for the counterclaim stands rejected. Accordingly, I pass the award. Therefore, 4 crores is what the learned arbitrator pays.
Damages?
Damages because I had contended that I was made to run from pillar to post and they committed, they were malafide. Therefore, he said 5 lakhs. I had asked for 8 crores in terms of 3 crores in terms of damages.
Arbitrator set aside everything. Oh no, 24.
The section 34 says on 2 counts. Penalty, there is a reference to some penalty. Therefore, it should be done. The learned arbitrator is incorrect in ignoring that fact. And the learned arbitrator has erred in giving the 2 crores to them. That 2 crores should have gone to them to meet the sub-vendor's liability. That is the limited ground on those 2 grounds only. And without any reasoning. Though no analysis to say that these are grounds which can be considered under section 34. Because my lords are aware that under section 34, it is not a first appellate court. Those same standard judgments are there. I will cite it later. But the principles are very clear that only under the specific grounds available under 34, the 34 court can interfere. It is not even a discussion, let alone a finding, that the grounds urged by them fall within these buckets of section 34. And therefore, I get the jurisdiction to intervene, and therefore I intervene. It is just his view supplanted to the view of the learned arbitrator. But I'll take my lord through the section 34 decisions after.
No, lunch we have a special matter.
We'll continue on.
We'll have it
We'll continue. Because now I'll need just barely about half an hour. The section 34 decision and some decisions on the position of law.
Say that we have heard Mr. Joshi as the senior counsel for the appellant. Not for further arguments. See next or next week.
December
12.
Next week. December. Very.
ಎರಡೂವರೆ ಮಾಡಿದ್ಯಾ ಮಧ್ಯಾಹ್ನ ರಿಸರ್ವ್ ಅದ್ ಕೇಳಿ ಹೇಳ್ತೀನಿ ಸುಬ್ರಹ್ಮಣ್ಯ ಅಂತ
ಬೆಳಿಗ್ಗೆ ಬಂದಿದ್ರು ಅವ್ರು.
ಕೋರ್ಟ್ ಆಫೀಸಾ?
ಸರ್ ಹೇಳಿ ಸರ್.
ಎಷ್ಟು ಪಾಸ್ ಅವರ್ ಆಗಿದೆ?
ಸರ್ ಪಾಸ್ ಓವರ್ ಎಲ್ಲ ಮುಗಿದಿದೆ.
ಹಾ,
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಇದೆ ಸರ್. ದೆನ್
ಹೌದಾ?
ಲಿಸ್ಟ್ ನಂಬರ್ 2
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ರೀಚ್ ಆಗುತ್ತೆ ಹಾಗಾದ್ರೆ.
ಅದಾದ್ಮೇಲೆ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Lordship.
The council here.
Yes. I requested, my lord, the other side advocate. He says, my lord, he's end up in sub-registrar office, so he cannot come down.
Will he be coming today?
No, he may not be, I think.
Tomorrow morning?
Tomorrow morning, I think.
Yes, ma'am, because we want that it should be mentioned in his presence.
Yes, yes,
Tomorrow, just tell him also.
yes.
Yes.
Serial number 30, list 130.
Agreement ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಏನು
Records have come in. Please, my lord, an agreement of sale, my lord, was entered into. There were three, my lord, persons, my lord, who were jointly owning a property in, my lord, Pinya village, my lord, Yeshwanpur Hobli. The agreement, my lord, sorry. The third, my lord, the first respondent before your lordship, my lord, was the third of them, my lord. Her husband sent the, my lord, the email seeking the draft of the sale deed. That was, my lord, in 2006, my lord, 17/3/2006, Exhibit C1. The draft was sent to him. They, my lord, sent back the draft. C2 and C3, my lord, are the draft, my lord, the agreement of sale sent by the appellant to Pratibhan. Agreement of sale was entered into, my lord, between the parties. All the three of them signed. Agreement was, my lord, that 10,000 rupees, my lord, was per square foot was the amount to be paid. 30 lakhs was paid, my lord, at the initial stage, my lord, at the time of entering into agreement. 120 crores, my lord, was payable at the time of registration of the document at the rate of 40 lakhs per person. Balance consideration, my lord, was payable within 1 year from the date of the agreement. That agreement, my lord, also specifies that, my lord, they will give us a power of attorney. Agreement of sale is, my lord, Exhibit C4. In furtherance of this, my lord, I, my lord, was the owner of a property in Malleshwaram. I, my lord, entered into an agreement for sale. Exhibit C53 before the arbitrator, my lord, was I agreed to sell my property for purchase of this at the rate, my lord, for sale consideration of 2 crores 56 lakhs 25,000. So that, my lord, I'll pay this amount, my lord, to them. Then, my lord, they obtained a title report. And ultimately, my lord, they lodged a complaint saying the original title deeds are lost. My lord, that is the respondent before your lordships. Exhibit C8, my lord, is the document, my lord, marked before the arbitrator with regard to that complaint. Huh? You have not given this, is it? But then, you know, you should give it earlier, no? What is this? Sorry, my lord, my apologies. We should have given it earlier. Convenience compilation documents are exhibits. So please see, exhibits are not there. My lord, I'm sorry, my profound apologies. We should have given it earlier. I thought it had been given, my lord. My lord, the agreement, my lords, get that at page, my lord, 17. 14. This is it's all right, don't worry about it.
17.
Up to please. My lord, the agreement, my lord, spells out, my lord, whatever I have stated, my lord. My lords get that at page 14.
Should be 14, not 17.
My lord, I'm sorry, it is 14. I know. That's why I said you should have cut it out.
14.
Yes, my lord.
Hmm.
My lord, whatever, my lord, the agreement, my lord, spells out, my lord, whatever I have stated.
Yes.
Then, my lord, the
Yes, Mr. Oga.
my lord, please come to my lord, page 53. That's the agreement, my lord, which we entered into for purchase, my lord, and for sale of our property.
Hmm.
My lords get that, my lord, at page 53, my lord.
Yes.
Blue in here. My lord, the blue ink, I mean, green ink or blue ink, whatever it is, I'm sorry.
Is sale of your property?
Yes, my lord. To my lord, fund it. I also had, my lord, my bank account, all that. That also we have placed before the trial, before the arbitrator. Then what happened was, my lord, after the police complained, saying that original is lost, they, my lord, came back and, my lord, they wanted, my lord, more amount to be paid to them, which also, my lord, we paid. Serial number 7 of my list of dates, my lords get that at page 3. 29/7, my lord, we paid 50 lakhs, 50,000, my lord, to the second respondent. And Mr. Pratibhan, my lord, is the husband of the first respondent before your lordships, who is, my lord, the third of them. Then, my lord, a sum of rupees 50,000, my lord, to the claimant and to the first respondent. Then, my lord, 5 lakhs rupees, my lord, to the third respondent. Exhibit C15, my lord, is this thing. We also gave them a check for rupees 25 lakhs. Ultimately, my lord, they issue me a notice. That's more important. They, my lord, claim that signatures have been obtained on blank. Very significantly, 2 of them, my lord, issue notice, not the third one. Third one writes back saying that no. You have not taken the signatures on the blank, because conduct is one of the things, my lord, which are always appreciated. To give grant or not to grant, my lord, the specific performance, conduct of the party is also, my lord, including the defendant, must be looked into. Please look at, my lord, what is it that they have stated in the legal notice, my lord, which is at exhibit C24. Are problem? When you give a list of dates, prepare a paper similar to this. And I thought you had all put it. It's all right. It's all right. Everybody, TCR
Records have come, so it's in the another appeal, connected appeal, records are there, records, trial court records.
Which matter?
The connected matter will be.
TCR has come.
4 and 4, 5 years.
Why 2 MFAs?
My lord, there were 2 of them. They filed, my lord, 2 appeals, because after the 3, one of them, my lord, sold the property in our favor. Well, there was subsequently a partition amongst themselves. So, my lord, one of them sold the property in our favor. Yes. Then, my lord, 2, my lord, section 34 before the trial court. Therefore, my lord, we had to file, my lord, necessarily 2 appeals before my lords, my lord.
Yes. No, go ahead with.
Yes, my lord. Then, my lord, he writes back. One of them, my lord, writes back saying that no. This is all not true. You have not taken it. In fact, my lord, my submission is, my lord, we exchange, my lord, the emails. with regard to this agreement and all that. And my lord, thereafter, my lord, what happened was they, my lord, claimed to terminate the lease. Then, my lord, I write back saying that, you can't terminate the lease. And, my lord, I will ultimately, my lord, go in for an arbitration for specific performance. The arbitrator, my lord, trial went on. The learned arbitrator, my lord, granted specific performance. He has come to the conclusion that I am, my lord, ready and willing to perform my part of the obligation. In fact, I have, my lord, in all, paid to the first respondent before your lordship 70 lakhs of rupees. I, my lord, have produced, my lord, this agreement of sale. I have produced, my lord, my bank accounts, my lord, which are at page 31 to, my lord, 31, my lord, is one bank statement. Then, my lord, 42, another bank statement. My lord, as to whether, my lord, I am ready and willing is a matter of fact. My lord, the arbitrator comes to the conclusion that I am ready and willing. Notwithstanding that, Section 34, my lord, court holds that, my lord, well, you have not shown, money, and therefore, the arbitral award, my lord, is set aside. Against which, my lord, we have come before your lordships. Short question for my lord's consideration, my lord, is as to whether readiness and willingness, my lord, is a matter of factual matrix, or, my lord, it's a question of law. My submission to your lordships is, if your lordships take, my lord, the arbitral award, which is, my lord, available in the appeal memo, my submission is, my lord, the arbitrator went into, my lord, in great depth into the entire aspect with regard to, my lord, readiness and willingness, came to a definite conclusion on factual matrix that, my lord, I am ready and willing. If that is so, my lord, my submission to your lordship says that, my lord, this was not a matter, my lord, where under Section 34, my lord, the district judge could have reappreciated the evidence and come to a different conclusion. My lords may, if your lordships take, my lord, the award, which, my lord, is in the appeal memo, in fact, very significantly, my lord, from our money which we pay to her, 70 lakhs, she purchases, my lord, first respondent before your lordships, purchases a property, my lord. We have produced that also, my lord. She, my lord, I agree to sell my property. She, my lord, from out of the advance pay.
To sell the property to purchase this property.
Yes, my lord, for funding some portion of it. 2.5 crores, my lord, 2 crores, 59 lakhs, my lord, is what, 56 lakhs is what we had entered into, my lord, for sale. She purchases a property from the advance that we have paid to her. That also, my lord, we have placed before the learned arbitrator. That document, my lord, we have placed before your lordships. Please come to, my lord, page 69. In that list of dates, my lord, that I had given to your lordships. Memo. My lord, appeal memo dalle idiyante. Sorry, my lord, it's in the appeal memo, my lord. That's what I'm saying, 69, yes. My lord, that list of dates, 16. Memo on the appeal memo. This is list of dates. Just relax. Don't get tensed up. We'll do it leisurely. Sale deed, my lord, 25/9/2006. If my lords recollects, the agreement that we entered into was, my lord, drafts were exchanged, my lord, in March 2006. Agreement was entered into in April 2006. We paid, my lord, advance. Thereafter, my lord, more monies were paid. We paid, my lord, to the first respondent nearly 70 lakhs. She purchases a property, my lord, from out of the monies that we have paid to her. Exhibit P47 at, my lord, R47, page 69. Yes, my lord. It's marked as exhibit R47, my lord. Please come to, my lord, page 69 of that list of dates I had given to my lords.
We have seen that.
Yes. And if your lordship sees, in favor of page 253, sorry, 71, Venkatalakshmi Pati, my lord, Venkatalakshmi Pratibhan. That's, my lord, the first respondent before my lords. She purchases this property from out of the monies that we pay to her. We, my lord, enter into an agreement for sale. They are not, my lord, willing to, my lord, after having taken my money, having, my lord, purchased a property, they are now saying that, you have given blank papers, you have taken signatures on blank papers. All that, my lord, was disbelieved by the learned arbitrator. My submission to your lordship says, under section 34, my lord, the scope is very, very limited. The question as to whether, my lord, readiness and willingness is, my lord, entirely within the matter of, my lord, appreciation of factual matrix. Therefore, my lord, the trial, my lord, the district court, my lord, could not have under section 34, my lord, interfered with that finding of the learned arbitrator. And learned arbitrator, my lord, went into the whole thing, went into, my lord, this agreement of sale that I have entered into, went into, my lord, my bank statements, that I had produced and marked before the learned arbitrator. And, my lord, come to the definite conclusion, my lord, that we are ready and willing. Therefore, my lord, the order passed, my lord, the only, sorry.
It has gone through the one which you wanted to sell it.
Yes.
What we have understood is.
Yes,
you
ma'am.
want to purchase this for which you have sold your house also.
Correct.
And for that you had given advance. She has also bought one.
Correct. I had given advance to this lady. She purchases a property. Therefore, my lord, my agreement of sale, my lord.
What happened to your agreement of sale?
My lord, that remains as it is because, my lord, this did not come through. So, my lord, this she filed, my lord, she said, you have all given. So, my lord, we have kept it on hold. Those people are also, my lord, will now file a specific performance against me. That's it. Therefore, my lord, my submission to your lordship says, the only ground, my lord, on which section 34 has interfered is that, my lord, we are not ready and willing. Nothing more. Please, yes.
Arbitrators finding.
Yes, my lord. Can I persuade your lordships? Take, my lord, the appeal memo, my lord, for a minute. Because the arbitrator's award, my lord, is in the appeal memo. It starts at, my lord, running page 117, my lord.
Yes.
And the
Who are the respondent number one?
respond,
Before the arbitrator?
my lord, respondent number one is one Guru. My lord, they are the three persons who are, my lord, that they were, my lord, jointly owning the property. Guru Prasad, Varadini, and, my lord, Venkatalakshmi Pratibhan. Guru Prasad has sold the property subsequently because they, yes, yes, he, my lord, they entered into a partition subsequent to enter into an agreement, he sold it. That also shows we have, my lord, we are ready and willing. That itself shows that, my lord, we are ready and willing. Secondly, the other two, my lord, have taken the third person, that is Venkatalakshmi Pati, my lord, Pratibhan. She purchases a property, my lord, from out of the funds that we have given her.
What about two?
Two, my lord, has not purchased, but then, my lord, my advance is with them. My submission to your lordships is, please look at, my lord, what is the finding given by, my lord, the learned arbitrator. My lords sorry.
The share of the first respondent is concerned. Was it could have been partitioned by meets and bounds?
Yes, my lord.
And you are in the possession of that part?
Yes.
Are you in the possession of that part?
Yes. That has been, it has been sold in my favor. That is one portion.
That's one portion.
Correct, my lord.
To the extent of portion, you have a sale deed.
Yes. Other two, my lord, there is no sale deed. My lord, it's a whole property. Only, my lord, one portion, my lord, on the corner, my lord, I have there.
Sale deed must be by all three together.
Yes, my lord. Agreement of sale. Purchase also by all the three of them together, my lord.
Okay.
They are the owners of, my lord, the entire property, three of them.
Their purchase. Their purchase of the property.
I think it is inherited by them. Inherited, my lord, not purchased. Inherited by them.
But though initially one sale deed by three, why you?
Correct.
Now to the extent of one, there is now a fresh
Yes.
sale deed has come.
Yes.
To the extent of partitioned.
Correct.
Okay. Yes, let's see the finding.
In fact, my lord, very significantly, section 30, my lord, 34 code sets aside the whole of it. Including, my lord, that sale deed which is made in my favor.
For a specific performance, ready and willingness must be there.
Correct, correct. I agree.
But you say what, at least going by what you have said is, though ready and willingness was finding of the learned arbitrator, which has been reversed.
Correct.
So reverse is not willing, you are not willing and ready to at least execute it. The consequence is it can't
Yes.
go ahead.
Correct. But then, my lord, if there has been a partition amongst themselves, one of them has already sold it, the agreement, my lord, I mean, the setting aside of the whole of the award, my lord, may not have been proper. It doesn't matter. Now today, my lord, it does not matter at all.
So possibly, you will answer this. This is the
Yes,
observation.
ma'am. The suit has to get dismissed is all that your lordship says.
The sale deed is by 3.
Correct.
The second after partition is by 1.
Correct.
So that sale deed, because of the executed by the third person, individually in his own capacity.
Correct.
Then it has a new sale deed which has come into effect.
Correct, my lord. Because there was a partition amongst themselves. That's it. Then, my lords may look at, my lord, the arbitrator that my lords get that at page 117 of the appeal memo.
Let's see the relevant.
Yes, my lord.
Now, how did you try to prove ready and willingness?
My lord, by producing, my lord, my agreement of sale with the purchaser, my bank statements, the amounts, my lord, that I have paid, my lord, where there are receipts, which they also admit. These are the things, my lord, which clearly show that, my lord, I am ready and willing.
Now, tell us one thing, there were 2 purchasers on your side. How many had executed on you and how many were there in the sale deed? You?
Sorry.
How many appellants are here? Because there are 2.
2 appellants, my lord, are before your lordships.
Who sought to purchase that property?
Together.
Together.
Yes.
So one, insofar you are concerned, you sold your house.
Entered into an agreement for sale.
The position for appellant 2 also. There was also ready and willingness for him also.
They are, my lord, together.
They are together.
Yes, yes, yes.
So even this house.
Yes,
which
yes.
Sold together.
That
They
agreement
given
is
the money
so
together.
correct, my lord. My lord, the issues, points for determination is at page 140, my lord, of the appeal memo.
Yes.
Serial number 7, my lord, clause 7 or paragraph 7 is whether, my lord, they are ready and willing to perform their part of the contract or whether the claimants were never ready and willing. My lord, that's the converse of it. Converse it. Now, with regard to this, my lord, please come to, my lord, running page.
He has framed it in the alternative or.
Correct. Or, my lord, that's right. Because they had contended that I was not ready. I had contended that I am ready. Therefore, my lord, both were points were framed with regard to both.
Which page?
My lord, please come to my lord, paragraphs are not there, but then your lordships will have to come to, my lord, the page numbers because he has, my lord, the learned arbitrator has said ABC, my lord, with regard to various paragraphs. Subparas, my lord, he has made. One paragraph, my lord, continuous paragraph would have been easier, my lord, to comprehend.
Possibly you have to refer to the page.
Yes, my lord. I'll tell your lordships. Para 23, my lord, if your lordships come to.
Which page is over?
I'm sorry. Para page 162. Sorry, before that, my lord, can I point out one paragraph, my lord? Please come to page 156. Learned arbitrator, my lord, holds what is the procedure to be followed and all that. I'll leave it at that. Then, my lord, various documents marked, my lord, are set out. Page 160, para 22. It is all the more important to mention here that the sale consideration mentioned in Exhibit C2 and C3 long prior to C4 sale agreement was the same mentioned in Exhibit C4. Draft agreement clearly contains that the consideration was 1,000 per square foot. This fact evidently contradicts the contention on the other side of the respondent. The respondent is them that what was agreed was 2,500 per square foot. Why, my lord, I am pointing out is every step, every stage, my lord, they have prevaricated.
Yeah.
prevaricated. Ultimately, my lord, conduct, my lord, is one aspect, my lord, which the court will always take into account, even of the defendant, for the purpose of granting or denying, my lord, the specific performance. Then, my lord, learned arbitrator comes to the conclusion, 2,500 per square foot, which evidently turns to be false. There was a gap of about 3 weeks from the date of Exhibit C3 to the date of the sale agreement. This also goes to show signing of Exhibit C4 by the respondents and attestation by of that agreement by Pratibhan was not at the spur of the moment. 3 weeks' time to ponder over the contents of the draft sale agreement was there for all these persons, and her say that what was agreed was 2,500 per square foot is an invention to fabricate story. Draft agreement C4 speaks of consideration at 1,000 rupees per square foot. As such, their story now put forth about the quantum consideration is an invention and a fabrication in support of their say, which is evidently untrue. As such, it has to be held. Consideration agreed was 1,000 per square foot and not otherwise. Then, my lord, in that, if your lords has come down A, admission results in saying, because, my lord, there was that exchange. Admission results in saying that there were exchange of emails between the claimant and the husband of the third respondent. Third respondent is the first respondent before your lordship, my lord, here, before my lords, in the appeal. These circumstances above stated amply go to show that, in fact, Exhibit C2 and C3, copy of the sale agreement, was sent to the husband of the third respondent. All the three respondents had full and detailed knowledge of their transaction and the terms of the proposed sale agreement, which culminated in the execution of Exhibit C4, dated 16/4/2006. Above circumstances fortify the say of the claimant that the consideration agreed by the parties was the same as reflected in Exhibit C4. Consequently, version of respondents about C1 to C3 cannot be believed. C1 to C3 stands proved in the circumstances narrated above. Evidently, in order to test the veracity of the document, a party relying upon it can lead independent evidence or fall back upon the circumstances unfolded on record. In view of these factual aspects and the circumstances unfolded, and also by a clear admission of by the third respondent, to the effect that these emails have been emanated, they admit the emails, have been emanated from the claimants to her husband, and vice versa. He writes also back. It cannot be said that documents Exhibit C1 to C3 are concocted and there was no exchange of draft copies of the sale agreement between the parties prior to the execution of the sale agreement Exhibit C4. For these reasons, irresistible conclusion is that the respondent had knowledge of the terms of the sale agreement, including consideration of 1,000 rupees per square foot. It is undisputed that the contract C4 came into existence on 16/4. My lord, I'll skip all that. Then, my lord, they have signed all that, my lord, is mentioned. Please come to my lord, my lord, in this itself, since my lords are at page 162, last 4 lines. 5 lines. That means Exhibit C4, for which the respondents have signed and Pratibhan put his signature as attester, was not on blank paper. Their contention is all on blank paper. This goes to show version of the other side that the respondent that had signed blank papers is utterly false in view of the admission of RW2. RW2, my lord, is these aspects go to show theory about the signatures have been taken, so and so, so and so. Then, my lord, consideration amount. Next page, my lord, if your lords has come to. That is page 164D. Consideration amount which has been reflected in C4 was as per the terms of the draft sale agreement. My lord, I skip this because ultimately, my lord, it was agreed that, my lord, they'll have to pay this amount within a particular period, all that. Please come to, my lord, page 165. Deposition of the second respondent at G, my lord. It is all the more important to state here, deposition of the second respondent, she has admitted as follows. On the date when I signed Exhibit C4, it was a typed document. My lord, their argument, notice sent was blank. Version, my lord, before the arbitrator, blank. She admits it. On the date I signed Exhibit C4, it was a typed document. To a specific question on the other side, on the side of the claimant, to second respondent, none of the respondents have signed the blank papers. Answer is, all the respondents signed on the blank paper, including my brother-in-law, husband of third respondent, Pratibhan. Page earlier, my lord, she says, it was a typed copy when she signed. Then she says, in view of the specific admission, H, my lord, page 166 top. In view of the specific admission that she signed Exhibit C4, which was a typed document, under subsequent admission, evidence on this aspect, that all respondents signed on a blank paper, including Pratibhan, evidently turns to be a false, utterly false. Their edifice of defense, a number of aspects, including signing on blank papers, crumbles. Signing on blank paper defense has been given a clear go-by by the other side of the respondents in the evidence of RW2 by stating that on the date when Exhibit C4 was signed, it was a typed document. RW1, the first respondent, is an established real estate agent as professed by him, who is in the field with vast experience since the year 1988. When the check of 10 lakhs was given on 16/4 by the claimant as part consideration to him, when he accepted the check, when he has accepted the check and encashed it, now his version that is signed on blank paper, etc., cannot be believed at least, in the least. Then, my lord, the other, my lord, evidence also, my lord, is taken, my lord. That's why, my lord, I wanted to point out, my lord, next page, all that. Learned arbitrator, my lord, takes out, my lord, each of these, my lord, and the evidence specifically spells out that, my lord, they have been, my lord, giving varied stories every now and then. And, my lord, the learned arbitrator has come to the definite conclusion that they have been lying. Then, my lord, the next page also, my lord, he calls out, my lord, various depositions and admissions made by them. Please come to, my lord, running page. That payment made. Please come to, my lord, running page, my lord, 175. I'll skip the rest, my lord. (175)B, my lord, if you allow, just look at. This unequivocal intention in the contract presupposes and supports the financial capacity and the ability of the claimants to arrange for adequate amount whenever need arose, which need has been stipulated as per 2C. That's, my lord, payment, my lord, within a specified period and timelines, notwithstanding the time limit. This presupposes and fortifies the readiness and willingness on the part of the claimant to perform their agreement at any point of time when such an occasion arose. Notice is issued after 30/6/2006, and the action unilaterally taken on the side of the respondents indicate that the respondents want to destroy the fabric of the agreement on one count or the other so that they can come out of their contractual obligations. Clause 2C of the agreement of sale reflects, notwithstanding the fact that even if there is no registration of the document, if a contingency arose for the purchase of the property by the vendors, from out of the remaining amount, claimants have to pay such an amount for the needy respondents. All these recitals in the document clearly show that the intention of the claimants did not suffer from any mala fides. This provision in the document also clearly fortifies that the intention of the claimants were honest. Besides, it was advantageous to the respondents. Third respondent availed the benefit of that clause 2C in the contract to purchase a property at Kumaraswamy layout. This is the one, my lord, which I pointed out, the sale deed. She purchased, my lord. We give her, my lord, all these advance, my lord, in March, April. She purchased it, my lord, in September.
But how have you proved that it was from your money only?
My lord, I asked myself this question, my lord, I know. But the fact is, my lord, that she has purchased. I asked, my lord, if she had, my lord, one question, my lord, your lordships have asked me a pertinent question, I know. My submission to your lordships is, ultimately, my lord, please look at, my lord, the factual matrix. She did not purchase that property earlier. It is not her case, my lord, that I had entered into an agreement for purchase of that property even earlier. It is not her case. I can understand, my lord, if she had put forth that kind of a contention, yes. All that it shows is, after, my lord, I paid the advance, after, my lord, 6 months, she purchased this property.
Was there any questioning on this?
My lord, as far as this aspect is concerned, we have said, look, you have purchased this property subsequent to our agreement of sale and purchase, my lord, advance paid to you. That's what we have said, my lord.
That is a specific question.
I'll point out, my lord. The yellow and the no, there is one that too many documents were there. Just take out. There is one document. I'll just point out, my lord, there is one document. That email is there. Correct. Document. My lord, please come to. This is a list of documents, my lord. If your lordships look at list of documents, C7, page 62, sorry. Page 62, my lord.
Yes.
I have attached a draft copy of the sale agreement. We are going to sign the agreement on 1st of September. Please go through and comment on it. Pratibhan, my lord, this is sent to Kamath. My lords get at the top. From Pratibhan to Kamath. That's, my lord, the agreement that he enters into, my lord, there for purchase of that property, which ultimately, my lord, he purchases.
No, this is what she has purchased. This is what you have purchased.
No, my lord. This is what, my lord, she purchased. That is the third respondent. Pratibhan, my lord, is the husband of.
That's right.
Huh.
Why is it addressed to you?
My lord, he says, my lord.
It's like this, no, Mr. Rahula.
Yes, my lord.
He is purchasing from a third party.
Correct.
How are you involved in with that?
Because he wanted, my lord, more money and we paid it. In terms of the sale agreement, my lord, we paid more monies. Though, my lord, we were not required to pay. That's why, my lord, he sends it.
Doesn't say so. It's, see, I have seen the attached draft copy.
Huh.
We are going to sign the agreement. Please go through and comment on.
Correct. Now, please come back to, my lord, page 22. I'll tell you, lordships, why. Or 19, my lord, it will be, sorry.
Yes.
In page 19, that's C, my lord. C. Remaining amount is payable within 1 year from the date of this agreement in case the vendors require the amount for buying any property. Purchaser shall arrange for adequate amount for the purchase of the property from the balance agreed amount payable after the registration of the document and not wait until the expiry of the agreed date for paying the final amount.
Was your agreements between you and them executed?
2000, my lord, in April, my lord, April, my lord. 16th of April.
Now, where is that? Again, let's.
Email, my lord.
62.
31st of August. Email is 31st of August.
After that.
Yes.
So, if it is after that. So, then it is regarding her property which she intends to purchase.
Purchase. My lord, she wanted more money. And my lord, we paid, my lord, additional advance. And she purchases it. My lord, would your lordship again look at, my lord, her own sale deed? I'll tell.
She say, please comment on it for your comment or something like that, what she said.
Because she wants, my lord. My lord, would your lordship look at, my lord, that sale deed which she purchases?
So you can argue this is one of the components.
No, that's all right. This is one of the aspects, my lord, which I'm just pointing out to your lordship.
It to say that this is what she has done.
Correct.
Post.
That's right.
Money from you.
After taking money from me, she, my lord, takes all kinds of pleas. My lord, she purchases a property from out of my. And if your lordship look at, my lord, that agreement, please have a look at that sale deed itself. Please come to, my lord, running page. 60. What is this page? 65, my lord.
Yes.
What 65? 69, man. My lord, agreement to sell is at 1 minute. 63, my lord, is agreement to sell, which she enters into with, my lord, those persons who sold it to her in September. If my lords come to running page, my lords, 65.
No, it's right, Mr. Hoda. There is an agreement which she has entered.
Correct.
How would you say that is based on your money? Only thing which connects is you have paid advance. Based on that advance, it immediately follows presumption, possibly.
Not only that, paragraph, my lord, which I pointed out, my lord, in the agreement of sale. In case vendor requires more money, we will have to pay it. Notwithstanding, my lord, our payment is much later. Which I pointed out, my lord, at page 22.
For the purchase of the house.
Correct.
Does it say so?
Yes, my lord. The remaining amount is payable within 1 year from the date of the agreement. In case the vendors require the amount for buying any property, my lord, page 20 or 19, my lord, sorry. 19, my lord. A problem.
We have actually confused pages.
Sorry, my lord. Can I, my lord, in that event, can I suggest this?
Say whenever you say page number, the one not.
Lord, can I, I know. Can I do one thing? can I do one thing? Subject to my being corrected by your lordships. I'll take it back, correctly pagine it, have it tomorrow or the day after. Subject to your lordships convenience. I think that is better. Instead of confusing your lordships, my lord, with I should have done that.
It's all right. It happened with us when we were lawyers. It's all right. Come to
Yeah,
page
madam.
19. Come to page 19.
Yes, my lord. Remaining amount is payable within 1 year from the date of the agreement. In case the vendors require the amount for buying any property, purchaser shall arrange for adequate amount for purchase the property from the balance agreed amount payable after registration of the document and not wait until the expiry of the.
Please the cross-examination on this aspect.
Yes, I'll point out, my lord. My lord, I'll point out the evidence, but then please come to my lord exhibit page 59 in this itself. My lord, she enters into a MOU with us. After, my lord, that agreement of sale, she enters into, my lord, in September, 29th of September. Please come to, my lord. Bottom. Last para. Whereas, although the validity of the agreement is in force until 15th of April, the first party having decided to purchase alternate property and having finalized the deal with the intending sellers have exercised her right to get her 1/3 of her right entitled part of the sale consideration on or before 6/11/2006 and has accordingly received a sum of rupees 30 lakhs. Today, from the party or the first part, second part, thereby making the total receipt of the sale consideration of 70 lakhs. These, my lord, I should have, what I'll do is, I'll repaginate them, my lord, correctly. I'll give you a lordships, my lord, a better list, my lord, so that I'll email it and also, my lord. I think that's better instead of wasting a lordship's time, my lord, because page numbers, my lord, when you have three pages, naturally, my lord, it confuses us. And especially, my lord, when your lordships go back, there's nobody to assist your lordships. Even that happens.
This what you're saying is it has been purchased based on the advance given by.
Absolutely. This is, my lord, memorandum specifically spells it out.
Yes.
Then, my lord, the evidence your lordships wanted, my lord, that my lords may come to, my lord, her evidence. RW, my lord, 3. Starts at 219? 219 of, my lord, the list of dates.
Yes.
Please come to paragraph 11 at page 222. I submit that thereafter my brother and sister, my lord, they are brothers and sisters only for that.
Please.
Yes. I just wanted to show that, my lord, for that purpose only I wanted to read this. Then, my lord, please come to cross-examination. My lords, get that, my lord, at running page 235.
Mm-hmm.
235, my lord, second unnumbered paragraph. My husband is a BCom graduate. While he was at Delhi, he was doing business of HR consultancy. Since I was homesick, we returned to Bangalore. We were residing in a rented premises. Then, my lord, last sentence, my lord, in that particular paragraph, there are no differences of any sort between me and my husband at any time till today. My husband has never acted contrary to my intentions and interests till now. Then,
Yes, she says blank.
please. Yes, my lord. Please come to, my lord, page 238. sorry, my lord, page 237 bottom, I'll read that so that there's continuity, my lord. Last paragraph of page 237.
Did this sale went through, the one she purchased?
Yes, my lord, that sale deed itself I pointed out, my lord. Yes, my lord. That exhibit 47, my lord, R47, page, my lord, 69. I had no property, my lord. My lords may look at line number, my lord, last paragraph, line number 1, 2, 3, 4, 5. Before purchase of Kumaraswamy layout, I had no property of mine. I had gone to the claimant for consultation. On what date I had gone, I do not remember. In the month of July, August, I had done so. Some advocate by Chikkanna drafted the agreement of sale. I do not know where his office is situated. My husband had gone to Chikkanna for getting the sale agreement drafted. To the claimant's office during July, August, I alone had gone. I showed the claimants the draft agreement pertaining to Kumaraswamy layout. I had no documents to evidence that I had gone to claimant's office in that context. According to me, except in the above context pertaining to Kumaraswamy layout property. Kumaraswamy layout property is, my lord, the one she purchased. I had not gone to the office of the claimants at any time for legal advice. I had just kept exhibit R46, Xerox copy of the agreement pertaining to Kumaraswamy layout. I do not know why the original was destroyed, though I was the custodian of the original. So, my lord, that she went to the office of the respondent or the appellant before my lords with the agreement of sale. Thereafter, my lord, we entered into a memorandum. We pay, my lord, additional amount. She purchased the property. Therefore, my lord, my submission to your lordship is, my lord, this is one aspect, my lord, which will be borne in mind and which, my lord, the arbitrator has also, my lord, taken into account.
But how is that she purchased the property would have a bearing on your readiness and willingness?
My lord, no. All that I'm saying is readiness and willingness, my lord, I'll come to it. I just wanted, because, my lord, I thought, my lord, otherwise, my lord, I'll be going forward and going backwards.
They have not doubted, at least she has not doubted your ready and willingness. The fact that you gave money, she purchased it.
That's
if
right.
she had any doubt
Correct.
on your ready and willingness, she would have.
He would have, my lord, said.
Or she had forfeited.
Correct. She, my lord, wants money from me. She purchases it, her property. Ultimately, my lord, my lord, these are all, though the amendment says, my lord, today, my lord, there is no discretion vested. Earlier, my lord, the view was that discretion was there. Ultimately, my lord, it has to be put in the balance. The balancing act is what always was done in a suit for specific performance. She purchased a property. I, my lord, enter into an agreement for sale of my property. I want to purchase her property. She, my lord, purchases. I don't, my lord, get the property. Therefore, my lord, these are the aspects, my lord, which your lordships will definitely, my lord, will have a bearing on, my lord, then, my lord, with regard to, my lord, the arbitrator's award, please come back to, my lord, the appeal memo, my lord. Sorry. My lord, 175 was where, my lord, I was. Not 175. My lord, page 175, bottom, my lord. D, I read. Third respondent availed the benefit of a clause 2C of the contract to purchase a property at Kumaraswamy layout. There was no bar either for first and second respondent to avail the benefit of the clause, but since no occasion arose for them to invoke the clause, they have not availed of the benefit. That is the other two. Third respondent, that is the first respondent of my lordship, not availed of that. Then Exhibit C19 is a memorandum of understanding dated 29/9/2006, entered into between the third respondent and the claimant, which, my lord, this I pointed out, my lord, that a memorandum of understanding which he enters into, my lord, for purchase of that property. Then, my lord, please come to running page, my lord, 176 F, paragraph F. It may be noted that in Exhibit C17, the amount reflected in the sale agreement is 52,25,000, and in the said agreement, a sum of rupees 5 lakhs is claimed to have been paid by the vendors to the vendors, Mr. Kodanda Naidu, and another therein on 38. On the basis of these documents, claimants have stated they have organized a sum of rupees 60 lakhs to the third respondent. In view of clause 2C of Exhibit C4, C4, my lord, is that agreement between us. Said payment having been made in the following manner. So, my lord, why, my lord, I am reading this is, as your lordship, my lord, very rightly pointed out, she never doubted, my lord, my capacity to pay. That's all that, my lord, I wanted to bring to your lordship's notice. All the three, my lord, then, my lord G, all these three payments have also been acknowledged by the third respondent in the memorandum of understanding executed by her on 29/9 in favor of the claimants. First respondent in his deposition categorically affirms we had a grouse against the third respondent when she received 25 lakhs without our knowledge. That's the other, my lord, brother, sibling. We had a grouse against the third respondent when she received 25 lakhs without our knowledge in the month of September. We questioned the claimants about the payment of 25 lakhs to the third respondent. They told us that as per their discretion wish, they will have paid the third respondent. Third respondent admits the purchase of the property in her deposition. My lord, I'll skip this. Then, now let's go to this thing itself. Readiness and willingness. My lord, please come to running page 192. Para B, my lord. Thus, the respondent at times of need had facilities and guidance by a galaxy of advocates. Besides, they were sufficiently educated in their life. In these circumstances, the contention of the respondent that the claimants and their advocates are duped cannot be accepted. I leave it at that. Then, my lord, please come to para D at, my lord, page 193. Sorry, para 33. According to the claimants, various payments made to the respondents are as under. Guru Prasad, my lord, 16/4/2006, 10 lakhs. Varadini, my lord, 10 lakhs. Venkatalakshmi, my lord, Pratibhan, first respondent before your lords, 10 lakhs. 29/7/2006, Varadini, my lord, 50,000. 29/7/2007, my lord, Venkatalakshmi Pratibhan, 50,000. Guru Prasad, my lord, 50,000. Then again, my lord, on 22/8, Venkatalakshmi Pratibhan, 5 lakhs. 22/8/2006, 25 lakhs to Pratibhan. Then again, my lord, on 29/9, 30 lakhs to her. Totally, my lord, 91 lakhs, my lord, have been paid. Above amounts includes 1,50,000 paid as interest. As such, the principal paid by the claimants is 90,000. Total advance sale consideration claimed to have been paid by the respondent on various dates as stated above. Out of the amount, 91 lakhs 50,000. It is stated that 1,50,000 is towards interest as per Exhibit C 13 and 14. Though payment at serial numbers 1, 2, 3, and 8 on record is not disputed by the other side, by the side of the respondent, it is also undisputed. Payment under serial number 2 was made by 2 checks of rupees 5 lakhs each. Material on record do indicate one of the checks paid on so and so for 5 lakhs was dishonored by the bank on ground of insufficient funds. On this count, it was argued that this was one of the instances to show claimants were not always ready and willing to perform their part of the contract. And that was there was a default on their part to adhere to the terms of Exhibit C4 in letter and spirit about one of them, my lord, got dishonored. Second one, my lord, we gave. On the above count, it was vehemently contended on the side of the respondent that the claimants were not ready and willing to perform their part of the contract, which is a basic requirement. It is undisputed that the said check for rupees 5 lakhs was dishonored on 18/6 for want of sufficient funds. It is admitted by the second respondent the very same check was represented to the bank and it was encashed on 22/6. It was also undisputed. No notice of dishonor was issued by the second respondent to the claimant in that context. There is no evidence on record that as per the instruction of the claimant, she represented the check to the bank. But the fact remains, she represented the very same check to the bank within a range of about 4 days, encashed it. It has to be seen whether second respondent has acquiesced with the said dishonor of the check. Acquiescence may be defined, my lord. I'll skip all that. Then, my lord, please come to page, my lord, 198. Unnumbered paragraph 2, my lord. This payment of 25 lakhs as stated above pertains to Exhibit C16. Total amount involved was 30 lakhs 50,000. Under Exhibit C50, as already discussed, there is no suggestion to CW1. The signature was taken on blank papers and they was converted into Exhibit C20. Her signature to the document C20 is admitted. CW1 has already spoken about document for payment of 30 lakhs as per Exhibit C20. As per the said, as such, the total amount in all paid by the third respondent aggregates to 60 lakhs 50,000. Receipt of 10 lakhs by way of check in pursuance of Exhibit C4 is admitted by each of the respondents. Exhibit C13 contains 2 vouchers. Second respondent has admitted a signature to Exhibit C13, stating that she signed Exhibit C13 on a blank paper. It is important to note, C13 also contains receipt issued by the husband of the third respondent, and the third respondent in her evidence has admitted Exhibit 13. Signature of her husband is marked as Exhibit 13B. Every now and then, my lord, she says blank. See, husband, my lord, is a HR, my lord, consultant. He was, my lord, in a working, my lord, in Delhi earlier, came back to Bangalore. Known, my lord, the person, my lord, who knows, my lord, what is what and life. He, my lord, signs. And as already stated, where in respect of a signature, the voucher is admitted, burden of proving that the voucher was signed in blank was on the third respondent. Third respondent, her husband, are in cordial terms as admitted by her, and as such, defrauding his wife by various reasons, for various reasons stated above, does not arise. As such, C13, voucher signed and executed by the husband of so-and-so stands proved. Moreover, it is not so. Certainly, this third respondent's husband, Pratiman, ought to have entered the witness box to explain why and how his signature finds a place in so-and-so, so-and-so. Then, my lord, receipt of 50,000, my lord, all that, my lord, is referred to. I'll skip that. Please come to, my lord, running page. See, page, my lord, 200.
Yes.
First respondent is a person who has ample knowledge in respect of real estate. My lord, he is a real estate agent himself. That is the first respondent, who is now, my lord, before my lord, the second respondent. First respondent is Mrs. Pratibhan. She, my lord, has purchased the property. This gentleman is a real estate agent. Therefore, let's see what, my lord, the learned arbitrator holds. First respondent is a person who has ample knowledge in the aspect of real estate, as he himself has proclaimed that he is a real estate agent and broker for long standing. It is admitted by him that from the year 1988 onwards, he was working as real estate agent for doing brokerage in that business. For that, he was getting commission if the deal was materialized. He had done business in the real estate to his ability and satisfaction. This evidence first respondent goes to show he has long-standing experience in the trade of real estate, and it came to the sale of his own property. It cannot be reasonably apprehended that he wanted to sell for a lesser value than the existing market value. Then, my lord, the market value, my lord, is discussed. Please come to, my lord, running page. (202). Sorry, 201, my lord, F. They, my lord, cull out, my lord, the learned arbitrator culls out, my lord, the evidence of first respondent. These aspects are highlighted to substantiate the fact first respondent had sold and purchased the property as per guideline value. Likewise, third respondent admittedly purchased a house property in Kumaraswamy layout in the year 2006 as per Exhibit R47, and also sold the property as per Exhibit C50. And the consideration mentioned in the respective sale deeds were admitted by her that it was as per the guideline value, the transactions were effective. First respondent in his evidence states as follows. My lord, I skip all that. Now, my lord, please come to what do you want? It's all right. My lord, page 202, above, my lord, para 36, one sentence, my lord, I'll read. Third respondent admits in her evidence, my lord, above para 36. As on 17/10/2006, there was no difference of any sort between me and the claimants. Hmm? 203, my lord, if your lordships come to.
Yes.
Specific suggestion was D, my lord, last para. When a specific suggestion was put to RW1, in the advertisement given to him, free ads, he had mentioned the piece of property at 800 rupees per square foot. There was a suggestion about the value of the property put at 800 rupees per square foot is denied. In view of his categorical, unequivocal undertaking that he can produce such a copy of the advertisement given by him in free ad magazine, he has not produced the same before this court. Tribunal, non-production of such so-and-so can be subject to matter of drawing adverse influence. That's all right. Now let's come to, what my lord wanted was your readiness and willingness. Let's just show that and then. Page numbers, change. My lord, please come to page 211, my lord. 211, paragraph C.
Yes.
My lord, my lord, the newspaper, just one line before that, newspaper publication dated so and so, and the certificate dated 21/7/2006 issued by RW4 was not questioned by the third respondent. This fact also clearly fortifies the conclusion. Date set forth in Exhibit C4 for the purpose of registration of sale deed by the respondent and release of second installment of payment by the claimant has never reached the stage to impute that the claimants were not ready and willing on their part to perform their part of the contract as on 30/6/2006. Above all, power of attorney as agreed by in the agreement Exhibit C4 was not given by the respondent in favor of the claimants. First respondent during his cross-examination has stated hereunder, periodically, once in 15 days, I used to go to the claimant and ask them to complete the sale transaction as per Exhibit C4. No notice as such was given to the claimant about this till the issue of the notice at Exhibit C24. Testimony of first respondent clearly goes to show that even after 36, until the notice was issued, periodically once in about 15 days, he used to go to the claimant, ask them to complete the sale transaction as per Exhibit C4. This evidence infers respondent had executed Exhibit C4 with the full knowledge of its readiness and willingness and all that we can show. Then, my lord,
223.
223, my lord.
C and D.
There is no credible see, my lord.
C.
Sorry. There is no credible contra evidence on record to show that claimants were not ready and willing to perform their part of the contract and they did not have the necessary funds to pay. In Exhibit C4, in the preamble and clause 6 about the regularization of the title of the vendors have been spoken, and after termination of the contract, first and second respondent by virtue of the notice dated 12/10/2006, they have applied for certain documents in the context of regularization of Exhibit C28 dated 18/10/2006. In these circumstances, it has to be held that though the claimants were ready and willing on their part, and it was only due to the omission commissions on the part of the respondent in not regularizing the title as agreed in Exhibit C4, so as to secure perfect marketable title for the purpose of registering the sale deed. As such, there was no readiness and willingness on the part of the respondents to comply with the terms of the contract, so as to attribute lapses and breach on the part of the claimants. Though under the terms of the contract, third respondent was entitled to 40 lakhs after regularization, yet an amount rupees 60,50,000 was paid in all as unfolded on the records of the third respondent to enable her to purchase another property. This evidences the financial capability and capacity and resourcefulness and mental preparedness of the claimants for arranging and mobilizing the funds at any point of time when need be there. It is relevant to mention here that as already discussed above, both the claimants were having sufficient means to pay the second installment, and it was in the knowledge of the respondent, as could be seen from the fact that the second respondent has produced the passbook extracted at exhibit passbook extract of the first claimant and got it marked as Exhibit R33, in which credit balance exceeding 51 lakhs is visible between 6/10/2006 to 16/12/2006. And such an arrangement was made by the claimant before the receipt of termination notice got issued by the first and second respondent, such as readiness and preparedness under the stage by any stage of imagination cannot be attributed to an afterthought. Then, my lord, the same page, my lord, 224 bottom. Certificate issued by RW4 after the newspaper publication confirming that he had not received any claim from the public was on 27/2006, long after 36/2006. Interest as per clause 2B of the sale agreement was paid to the respondent long after 36/2006. That is, receipt for payment of interest was dated 29/7/2006 in respect of second and third respondent, and 2/8/2006 in respect of first respondent. Third respondent in her evidence admitted that after the discussion with the claimants on 28/8, she received further sum of rupees 25 lakhs white check bearing number so and so drawn on Canara Bank, which is marked as Exhibit C16, And on 27/6/2006, third respondent had executed the time limit, extended the time limit of the contract by executing Exhibit C4. Thereafter, she has received further sum of rupees 30 lakhs from the claimant under Exhibit C20. On 29/9/2006, executed a memorandum of understanding. C68/28, which is a letter written by the first and third respondent to the Tahsildar for grant of Vamshavriksha, that's the family tree certificate, was dated 18/10/2006. Unless power of attorney was also made available to the claimant, contractual obligations on the part of the claimant specified in the contract Exhibit C4 had not been complied with by the respondent. In view of the above facts and circumstances and record, time was not the essence of contract in Exhibit C4. Above all, the said finding is also fortified by the fact about the receipt of interest as per Exhibit C13 and C14, which were subsequent to 30/6/2006. Third respondent in her deposition has stated the registered partition deed among the respondents took place on November 2006. In November 2006, we decided to partition in order to protect the property from the claimants. That means they wanted to protect the property from the claimants by evading their contractual obligations detrimental to the interests of the claimants and the sanctity of the contract. That was a design in their mind, even as far as November 2006, much before the issuance of notice terminating the contract by third respondent on 3/1/2007. About this alleged partition, though it is stated that it took place in November 2006, nothing has been pleaded in their pleadings by the respondents. Moreover, the alleged document itself is not produced before this tribunal. During the course of arguments, on the side of the respondent, it was contended that since the contract in question, Exhibit C4, pertains to the property which belongs to the respondent, since the claimants were their advocates at one point of time, that's not long prior to all this, the agreement of sale in question is against public policy. Contents were not supported by any pleading, thus there is no foundation, etc., etc. Then, my lord, please come to page 228.
Yes.
Sorry, 227, my lord, bottom. The above discussion, my lord, the learned arbitrator, my lord, goes through the whole thing. About discussion clearly leads to conclusion. Contract could not materialize in view of the willful prevention. They did not, my lord, give us, my lord, that family tree, did not, my lord, give, my lord, what we had asked for, did not give us the power of attorney. About discussion clearly leads to conclusion that the contract could not materialize in view of the willful prevention breach and breach on the part of the respondents 1 to 3 on various aspects, which has been discussed in earlier paras. In fact, their prevention of putting spikes in one way or the other does not in the least prejudice or affect the virus of the contract and the rights of the claimants to have relief if they so entitled. Materials on record indicate that by virtue of Exhibit C24, first and second respondent unilaterally terminated the agreement, but the first respondent has subsequently under Exhibit C25 has withdrawn the termination notice as far as he is concerned. Third respondent on 3/1/2007 also terminated the contract by virtue of Exhibit C14, R49. They are all unilateral termination which will not in any way affect the rights of the claimants to enforce the contract. Moreover, in Exhibit R45 dated 6/1, which was got issued by the third respondent, it has been clearly stated, third respondent has no objection to refer the issues to civil nature to arbitration as stated above. CMP was filed, so and so, so and so. Then, of course, my lord, the whole lot of judgments, my lord, cited by all parties, my lord, is referred to. Please come to, my lord, page 233, para 53. Wherever the ratios of these decisions are applicable and germane, consequential conclusions have been arrived at by the tribunal. In that background, tribunal has come to the conclusion on the materials on record, including the law applicable. In view of the above discussions made, tribunal on material on record, including the law applicable, has come to the following conclusion. There was no inducement by the claimants on respondent in respect to the contract in question. There was no fraud played by the claimants on the respondents in bringing out the contract. There was no misrepresentation, coercion practiced by the claimants on the respondents. There was no undue influence practiced by the claimants on the respondent. There was no undervaluation of the property as alleged by the respondent on the aspect of sale consideration. Sale consideration is adequate and not unconscionable. Contention of the respondent that certain blank signatures taken by the claimants as contained by them is false. There was no fraudulent misrepresentation as contained by and canvassed during the course of the argument. Agreement in question is not one-sided. As alleged by the respondent, claimants have never exploited or dominated the will of the respondents in formation of the contract, and as such, the claimants as advocates have not abused their position. Unilateral termination of the contract does not alter or affect the virus of the contract, and the claimant's right to enforce the contract remains intact. Claimants are always ready and willing to perform their part of the contract. Total payments made by the claimants, the respondent in all, 91 lakhs 50,000 towards their contractual obligations arise out of the agreement in question. This amount includes 1,50,000 paid towards interest as already discussed. MOE is not acted upon till now by both the parties. That is, my lord, the subsequent, my lord, when she wanted, my lord, 30 lakhs for purchase of that other property. Okay. Okay. The contract in question is not vitiated by fraud, P. And the sale agreement in question dated so and so is product of free will, etc., etc. Thus, it is categorically held para 54. C4 is a product of consensus ad item between the parties, so and so. My submission to your lordship is, my lord, the 4 things, my lord, I want to place before your lordship. That, my lord, there was an agreement undisputed today. That, my lord, we paid, my lord, to the third respondent 70 lakhs, notwithstanding, my lord, the payment to be made, my lord, much later, undisputed. That, my lord, I had entered into an agreement for sale of my property, my lord, to fund this, my lord, to, my lord, get 2 crores 56.
The schedule for you to pay the amount.
My lord, would you let's just look at, my lord, the agreement itself now. Let's look at the agreement. My lords may come to, my lord, the agreement, my lords get that in the list of dates itself. Please come to, my lord.
Did you adhere to the schedule?
Yes, my lord. I would say, my lord, yes. But 2 things. They were also required to do certain things. I was also required to do certain things. My lord, if they did not do it, my lord, question is where? Please come to, my lord, page 18, 18. Purchases 2, my lord. Sorry. Para 2.
Yes.
Purchasers have agreed to pay the agreed sale consideration as follows. 30 lakhs to be paid in the name of 3 vendors at the rate of 10 lakhs per vendor. Sum of rupees 120 lakhs shall be payable at the time of registering the document in the name of the vendors. At the rate of 40 lakhs per each payable either by the purchasers themselves or their nominees.
Registry stay had not come.
No minute. Remaining amount is payable within 1 year from the date of this agreement in case the vendors require the amount for buying any property, purchasers shall
pay 30 lakhs.
Yes.
The name of 3 vendors at the rate of.
Correct. Correct. That I have paid. Then, my lord, this.
Once the check got bounced.
No, that has been then cashed again. 2 days later.
4 days.
My lord, 4 days later. My lord, what happened is, my lord, bank sometimes, my lord, I'm in fact, my own.
But tell us one thing, then within those 4 days, the money was put.
No, my lord.
So it was insufficient funds.
That is what, my lord, they say. If your lordship say, I'll point out. Just take out that.
Sir, the meaning of insufficient is there are no funds.
No. My lord,
Technical
correct. Insufficiency, my lord, funds being not there. Now, my lord, please take the.
Comes to a conclusion,
no, my lord.
time is not the essence.
No, not that. That 5 lakhs, my lord, did not relate to, my lord, this 30 lakhs. 30 lakhs, my lord, is received by them.
What is relatable to?
It is, my lord, subsequently, my lord, they wanted, my lord, more money, my lord, we have paid, my lord, every now and then. In that, one of them.
Schedule undergone a change.
My lord, schedule has not undergone a change. But then, my lord, they wanted money, my lord, every now and then, my lord, we have gone on paying. Please look at, my lord, the schedule now. Please, let's look at the schedule. Schedule is 30 lakhs at the time of agreement paid. Second is 120 lakhs payable at the time of registering the document. That has not come at all. They have not registered anything.
Between there is a variation.
My lord, variation was they wanted more money for, my lord, purchase of a property, which we gave.
How much was the more?
This lady received, my lord, 70 lakhs, as against, my lord, 10 lakhs. Please look at it. They first respond before my lords.
So cumulatively 70 lakhs.
Yes, she received. She, my lord, received herself.
70. As against 10 lakhs.
Yes, my lord.
And each received 70.
No, others, my lord, did not receive 70. She wanted, my lord, she wanted to purchase.
She wanted to purchase.
Therefore, my lord, we gave her. Though, my lord, the agreement says you have to pay, my lord, the balance of 120 only at the time of registering the document, which they did not register. They had to give a power of attorney. Did not give a power of attorney. And my lord, they, my lord, give a police complaint after entering into all this, taking my lord 30 lakhs, saying that the originally is lost. That also I pointed out to your lordships. But in the background of all this.
So original loss was between those 10 lakhs and 120 lakhs.
Yes. 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 Complaint given. We don't know, my lord, when it was lost. They say it is lost.
You agreed for a higher amount, or they asked for a higher amount.
No, my lord. Please have a look at, my lord, the MOU, which we have entered into with the lady. My lords, get that. At, my lord, running page. That MOU just pointed out. Where is that? Hold on.
So all these finding of facts have been set aside 34.
My lord, everything. Correct, I say. Readiness and willingness. Trial court has set aside, my lord, only on the ground of readiness and willingness. That's
important.
correct. My lord, in a suit for specific performance, readiness and willingness must be there. No doubt at all. My submission to your lordships is, for readiness and willingness, when, my lord, am I required to, my lord, my lord, there's a timeline. There's a timeline for me, there's a timeline for them. My timeline, my lord, will kick in as indicated here. At the time of agreement, 30 lakhs paid, no doubt at all. Tick. Second, 120 lakhs, my lord, at the time of registration. Registration itself has not occurred. Section 53, my lord, of the Contract Act, my lord, when there are reciprocal relations, when, my lord, he is required to do a particular thing, based on that, my lord, I have to do a particular thing.
Yes.
120 lakhs payable at the time of registration, which they did not. Yet, I, my lord, keep on paying, my lord, every now and then.
To her.
Her, no, and others also paid, my lord, some amount. May not be, my lord, 70 lakhs. Yes. I have also paid, my lord, to the others about, how much have you? No, there were, the first, my lord, the elder brother, the brother, we paid the whole of it and, my lord, purchased the property itself from him. My lords may recollect, out of the three, after, my lord, they entered into a partition or whatever it is, he, my lord, I paid him the whole of the money. As far as, my lord, the others are concerned, second respondent has received 10 lakhs and 50,000 interest. My lord, one of them, my lord, received only 10 lakhs. He didn't, ask for more. But the other one, that is first respondent before my lords, my lord, she has received 70 lakhs. The other brother, my lord, has received the full money.
Sold it to you.
Yes. Therefore, my lord, my submission to your lordships is, all these are aspects, my lord, which has to be holistically looked into, is all that I'm saying. Ultimately, my lord, we can't, my lord, look at one aspect and then say, well, there.
One thing, Mr. Hola.
Yes.
What is the specific performance is which agreement?
Specific performance of this agreement, my lord.
What is the date?
My lord,
Again, the three siblings.
Yes.
Okay.
16/4/2006 agreement.
Now, now we are putting it to you.
Yes, my lord.
Is that agreement not superseded by one separate agreement to a part of that property by one of the siblings?
There's no agreement. He sells it. I purchase it.
No, there must be a sale deed.
After the decree, my lord. After the decree passed by the arbitrator, I purchase it, not earlier to that.
The decree passed by the
Arbitrator.
you purchase.
Yes.
What is the effect thereof? That at least to that extent, is it your case? To the extent of the third brother or one of the siblings who has sold his share, this specific performance has been granted or has been acted upon.
Acted upon.
The agreement has been acted upon.
Correct.
Now, is that based on the same agreement or a fresh agreement?
Same agreement, my lord.
Oh, is the same agreement?
Same agreement.
No, it's fresh agreement.
No.
How would you demarcate? How would you separate it to the extent?
Lord, can I put it in this manner, subject to might be corrected by your lordships? He says, my lord, as per the terms of this agreement, each has to receive, my lord, X amount. I pay that X amount and purchase it from him. Not, my lord, X plus something.
Right. You have gave that X amount. No, we want to know, that was only an agreement to sell. To the extent of this portion, there is a sale deed.
Correct.
Based on that.
Yes.
Based on decree.
And my lord, after the decree.
No, is it based on decree?
After the decree.
after the decree.
Correct.
But does that, any deed, conveyance deed which has been executed refers to the decree of the arbitrator. And in furtherance thereof, this has been executed.
My lord, please come to, now take out that sale deed. Take out the sale, I'm not, 1 minute, my lord, I'll just point out the sale deed itself. My lord. Let's take out the-
So this would be relevant.
No, I understand, my lord. Ultimately, my lord, we sit here, in fact, I always say, both of us, my lord, will quarrel here and go and have, my lord, buy 2 coffee, place it on your lordship's shoulder.
That is the beauty of this profession. You may be fighting here. You are also part of that. Don't mind.
Yes,
don't
my
mind
lord.
it. You are also going out and having.
Show it. Copy got copy got Sir. My lord, would your lordships come to page, my lord, page numbers are not there. My lord, para number 10, my lord, that is 1, 2, 3, 4, 5th page, my lord, if my lords, para 10. Whereas the vendor along with his 2 sisters, Varadini and Venkata Lakshmi Pratibhan have entered into an agreement of sale date to so and so with the purchaser for sale of so and so. So transaction due to some irreconcilable difference between the parties, transaction ended in litigation by virtue of this, my lord, appointment of another arbitrator by the High Court.
No, see the last 3 lines.
Yes, my lord.
Convey the sale deed in respect of the individual share in the property.
Correct, my lord, because he has,
In favor of the person.
correct, he has, my lord, subsequently, my lord, they have partitioned. Please look at it, my lord. They can't, my lord, today, having partitioned after, my lord, the agreement of sale, he has to sell, my lord, his share and they are allowed to sell their shares. That's all. But the fact is, my lord, it relatable to, my lord, the agreement of sale, the award passed by the arbitrator. That's all, my lord. That doubt your lordship had, my lord, therefore I had.
The agreement to sell is referred.
My lord, please come to, my lord, top page itself, my lord. 10, para 10. Vendors along with the sisters, Varadini and Venkalakshmi. Yes.
Yes.
Therefore, my lord, my submission to your lordship says,
Is it your case to the extent of 16/4/2006 specific agreement has been acted upon
Correct.
by one of them?
yes. Not only that, they, my lord, issue a notice saying that, my lord, you have taken a blank signature. The brother says, sorry, this is not correct. And, my lord, the arbitrator goes into the whole thing, comes to the definite conclusion, my lord, that there is no blank signature, my lord, it's all, my lord, validly executed, entered into, signed, my lord, with the full knowledge. Not only that, that's why I said, I can understand, my lord, if that 10 lakhs was all that they had paid and nothing else. No. Subsequently, my lord, she enters into an MOU, says, I want to purchase another property, takes, my lord, more money. 70 lakhs have been paid.
She doesn't come forward. So she has not come forward. You are through, we will hear him.
Yes, my lord. I'm not only few judgments, my lord, for my lord's consideration, my lord. Not that, my lord, these are new to your lordships.
But on what proposition?
My lord, one is readiness and willingness, my lord, is a matter, my lord, factual aspects.
It's a question of fact and we'll say. mixed
No,
question
latest
of fact.
judgment, my lord, says, finding of fact, including, my lord, readiness and willingness, normal rule is, my lord, it should not be interfered with. Even, my lord, in a appeal, that's what they say, more so, my lord, in 34. That's only for that proposition, my lord, I am relying upon a 2019 judgment, my lord, of the Supreme Court.
The context of arbitration.
No, Lord, it's in the context of, my lord, specific performance itself. It may not be arbitration, but then, my lord, today, I'll point out this, my lord, subject to my being corrected. Section 34 is, my lord, far, my lord, narrower in compass than, my lord, a regular appeal. Even in a regular appeal, my lord, this can't be.
In the sense, it's not a first appeal.
Correct. Correct, my lord. My lord, page number 1, my lord. It starts 2019-17 SCC 71. Please come to, my lord, paragraph 15. at running page 10, my lord. My lords, get the page numbers, my lord. We have put a continuous page number. Peruse the aforesaid judgment would show jurisdiction in second appeal is not to interfere the finding of fact on the ground that the findings are erroneous. However gross or inexcusable the errors may seem to be. Finding of fact will also include the finding on the basis of documentary evidence. Jurisdiction to interfere in the second appeal is only where there's an error. My lord, finding of fact, my lord, in view of the fact, we find that the High Court would not interfere with the finding of fact recorded after appreciation of evidence merely because High Court thought another view is possible. My lord, section 34, my lord, would be that only because you can't, my lord, reassess an evidence. My submission to your lordship is that also, my lord, we have kept for my lord's consideration, not that, my lord, it is something new because day in and day out, my lord, people will be filing, my lord, giving your lordship's judgments and your lordship will be, my lord, rendering judgments, my lord. On facts, my lord.
Any judgment on 34 on specific performance?
My lord, this is a specific performance suit only.
That was in the context of second appeal, Mr.
In the context of, my lord, second appeal. Second appeal, correct?
Appeal of the CPC.
Yes, my lord. But please look at the second appeal, factual matters can't be, my lord, reassessed.
It is perverse.
Huh. Unless it is perverse.
Second appeal,
Correct.
question of law,
So,
maintainable.
my lord, is section 34. Please look at, my lord, Sangyong and all those other judgments, associated builders. Unless it is perverse, you can't reassess. That's all, my lord. Only for that limited purpose, nothing more. Please come to, my lord, page 34. 24. This is, my lord. Bande. Please come to, my lord. It starts at page 12. Sorry, page 14. 2005. 12 SCC, my lord. 1995, 5 SCC 651. Paragraph, my lord, 10 at page 24. On these contents, the following points arise. Whether the appellant is right in contending that arbitration clause, Bande. Main agreement did not permit the arbitrator to deal with the disputes relating to interior design. I'll skip that. Please come to number 3 and 4. Para 10, subpara 3. Whether the arbitrator is not entitled to pass an award directing specific performance on an agreement of sale and the subject matter of dispute is not capable of arbitration under 34(2)(b)(1) of the Act. Whether the appellant could question the factual finding relating to default, time being the essence of contract, readiness and willingness, etc., before the arbitrator under section 34. That is, my lord, answered.
Is the time not being the essence of the contract of the finding of the arbitrator has been varied?
No,
by the 34?
no, my lord, no. Readiness and willingness is all that he has said, my lord. That has not been varied, my lord. That is not. No, the last one is all that I would say, my lord. Whether the appellant could question factual finding related to default of time or the essence, default of time being the essence, then readiness and willingness, etc. Both.
Under 34.
This is under 34. Then, my lord, para, the finding, my lords, get that at para 37, page 33.
Yes.
This point concerns the issues between the parties and the merits of the award relating to default, time being the essence of contract, readiness and willingness, etc., etc. These are all issues of fact. If we examine section 34(2) of the Act, relevant provisions of which have already been extracted under point 1 and 2, it will be seen that under clause B of section 34(2), interference is permissible by the court only if the subject matter dispute is not capable of settlement of the arbitration. Arbitral award is amount is in conflict with the policy of India. Explanation to so and so, so and so. Then, my lord, explanation to provisions say that without prejudice of generality of subclauses 2 and clause B is declared for avoidance of doubt that an award is to be treated as in conflict with the public policy of India if making the award was induced by, affected by fraud, corruption, etc., etc. Section 75 deals with the confidentiality, etc. We do not have any such issue before us falling within section 34(2)(b)(2). Factual points raised in the case before us, to which we have referred earlier, do not fall within the ambit of section 34(2)(b)(2). Coming to section 34(2)(b)(1), we've already held that the subject matter of the dispute is not incapable of so and so. Of course, my lord, they have not dealt with, my lord, in extent so. I understand this paragraph. But if one reads, my lord, the question that was posed to themselves in paragraph 10 and, my lord, 37, I would say, my lord, that scope is limited. That's all. More than that, my lord, I will not say. Then, my lord, of course, we have kept, my lord, other judgments, my lord, reappreciation of facts, evidence.
Yes.
Reappreciation of evidence and facts and law, my lord, would not arise under 34, my lord. That we have kept, my lord.
Where is the finding of 34?
Please, my lord. 34, my lord, I'll come to it. Please take, my lord, the appeal memo. Virtually, my lord, he seeks to reassess the whole thing, reappreciate the evidence. It starts at, my lord, running page 23 of the appeal memo, my lord. Please come to, my lord, page 44. Points which arise for consideration. 8, my lord, para 8. Whether the plaintiffs have made out any ground as enumerated in section 34 of the Arbitration Conciliation Act to set aside the award dated so and so, passed by the fifth respondent, sole arbitrator. Then, he, my lord, seeks to reassess the whole thing. Please come to page 81. Learned arbitrator was pleased to hold that the defendants 1 and 2 have more than sufficient financial resources and avenues to mobilize the consideration at any point of time to meet the contingency. In the light of this finding of the learned arbitrator, it is necessary to look into the Exhibit C5 and C6, which have been produced by the defendants 1 and 2 before the learned arbitrator. Exhibit C5, which commences on 18/4/2006, ends on 6/6/2006. Even this is not correct, Allah. Even this is not correct, my lord. It does not end on 6/6. We have placed, my lord, the document itself. We also can, my lord, look at the original itself before the trial court, but which has come from the arbitrator himself. Balance available as on 6/6 was only 31,228. Similarly, Exhibit C6, it commences on 18/4, ends on 2/6. He looks at, my lord, only 2 pages, 1 page and 2 page, and then, my lord, says, my lord, this is what it is. In fact, my lord, can I persuade your lordships? Look at, my lord, the document itself which we have placed before your lordships. Please come to, my lord, the list of dates, my lord. Doesn't matter. Page 31, my lord, of the list of dates. Goes on up to, my lord, 7. 18/9/2003 onwards. Please come to, my lord, running page 48, 49, 50, 49. It is up to, my lord, 31/12/2007. He looks at only 1 and then, my lord, says it. 1 page. Page 50 onwards, my lord, is the other passbook. Which, my lord, only they produced. This, my lord, 1 page they produce, and the learned arbitrator looks at that and says only up to.
But that's fine.
Yes, ma'am.
Now, if we don't have the required amounts.
My lord, I'll rely upon, my lord, 4 judgments of the Honorable Supreme Court. You need not jingle the, my lord, money. I have entered into an agreement, my lord, for sale of my property. When does, my lord, it become payable? That's the issue for my lord's consideration. When it gets registered. At the time of registration, my lord, I'll buy then, my lord, I will get money from.
What really made, or why it could not be taken to that stage?
Because, my lord,
the
cancellation.
Sale deed lost.
Sale deed lost. And then thereafter, my lord, they did not bring that family tree. That had to be. Power of attorney not executed. So, my lord, they were required to do certain things, my lord, which they did not do at all. I, my lord, enter into an agreement for sale of my house, my property. My lord, I ask myself this question, why will I do that? So that, my lord, I purchase, my lord, this property, my lord, where we can have, my lord, bigger house and some small industry, my lord, which the one of them, my lord, wanted to, whatever. My submission to your lordship says, ultimately, my lord, this is the thing. Conduct of, my lord, the defendant and the conduct of the plaintiff. They were required to do certain things, my lord, then by virtue of, my lord, the Contract Act, I, my lord, am required to do that, my lord, only when, my lord, they comply with it. Can it be said that, my lord, I'll have to have, my lord, the money in my pocket, my lord, from the very beginning till the end? Answer is no, my lord. Earlier view was, you will have to have money, my lord, throughout. That, my lord, has been watered down, my lord, drastically, because ultimately, the agreement that I have entered into for sale of my own property is one aspect. Second, I have periodically paid them. Whenever they wanted money, my lord, I have periodically paid them. I have already purchased, my lord, one portion of the property. I have, my lord, paid her, my lord, 70 lakhs for purchase of, my lord, a property for her, my lord, which she purchases.
34, by the time the 34 was being argued, you purchased the third portion.
No, yes.
But was it told to the 34 court?
Yes. Argument, my lord, conducted by my learned friend. Yeah.
And it did not accept it.
My lord, he did not take it into account at all.
Any finding on that?
No, no finding.
Okay. We'll continue, we'll hear you next date.
Yes.
Just say that we have heard Mr. Bhola Lanat, Senior Counsel, for the appellants to come up for the arguments on behalf of the respondents, all the respondents.
But there are two respondents. I think I request this honorable court to permit me to argue after Mr. Chalapati. Is also present. After Mr. Chalapati, the senior advocate.
I'm represented by Mr. Chalapati.
I appear for the first respondent in the matter.
Yes.
But second respondent is represented by a senior advocate. Permit me to argue after him. That's what the request.
We don't
I have no objection, Manan. I will argue the matter.
Because
we'll hear you. What is the seniors?
Chalapati.
SKV Chalapati.
So Chalapati, we will hear you next day.
My lord, I have no objection to argue the matter tomorrow. I will
We'll
argue.
give you date. We will give you date. Just give a date in December.
They'll give a date and fix. They'll give a date. Fix a date.
Pardon?
Yeah, date.
They'll fix a date. Held on.
11th and 12th.
18th. 18th December.
Please.
Very good.
They did not file appeal also.
2:30.
We'll have it at 2:30.
That's all.
2:30.
Please. Grateful.
I'm just call that list. Man.
Please.
List number 2. Serial number 2.
List 2, serial 2.
Who appears for the other side?
Mr. Ranjan Kumar.
So we'll just call other matters.
Serial number 3, Shri Venkateshwaran.
My lord, appearing for the respondent number 1, my lord.
Yes.
Lord, Lord, this is an appeal which has been filed by the appellant against the order of rejection of plaint. The appellant has challenged surfacey action, that is surfacey sale, in a commercial court. And so consequent to that, the respondent bank, the first respondent bank had filed an application under Order 7, Rule 11, contending that the whole...
You are for the bank, ma'am?
Yes, yes, my lord. Yes, my lord.
Who appears for the appellant?
One Mr. Venkateshwaran appears, my lord. He's been coming to court, but I think he's not there today.
Correct.
In fact, he has challenged the sale which was conducted in 2010, my lord. This is a sale deed.
You say that he should have gone in 17.
Yes, my lord. His contention is that there is no SSI ID, procedure is not being followed.
Has he pleaded fraud?
No, my lord. There is no fraud, my lord. There is no fraud pleaded. Yes.
One
No,
minute.
there is no. My lord, his main case is that in fact in the appeal,
Pleaded or not?
it's not pleaded, my lord. There is no plea of fraud. In fact, he says that SSI ID has not been registered. He has not received notice. The borrower, the guarantor, my lord, the appellant is the guarantor. The guarantor has not received notice. So these are the essential grounds that are.
We will have it in the regular list.
Yes, ma'am.
Let's see, we will have it in the regular list.
Yes, ma'am. Please, ma'am.
None for the appellant, re-notify. Just give it next week, ma'am. Monday, Tuesday, Wednesday. 12th of December.
Please, ma'am. Yes, ma'am. Grateful, ma'am.
Number 4. Number 4.
Yes.
For appellant, my lord. My lord, we have to produce a translated copy in the exhibit, my lord.
Which translation?
My lord, they have produced the 34 proceedings. They have produced one Kannada document, my lord. It may required for the.
Let's see, what is the Kannada document?
Additional document they have produced.
Is it a part of the record?
Yes, my lord. Part of the trial court record.
Yes.
Just say that, leave it at that in the list. We will keep it in the list, file your translation. And call the next matter, ma'am.
Serial number 5. Sir, serial number 5.
We'll just have it in the list.
5.
Next, ma'am.
6. Lakshmi Shah.
Happy for the respondent, my lord, in the serial number 6.
6. Venkatesh.
Yes.
My lord,
Yes.
What is the issue, Mr. Kulkarni?
my lord, there was an agreement to execute the civil work.
Sir, court is
Since
audible.
my lord, the contractor has raised certain dispute, alleging that the short payment and also my lord, damages. And since there was
has been granted.
Yes, arbitrator has granted and confirmed by the appellate court.
How
Concurrent,
much?
my lord, it comes to about 37 lakh rupees on odd. Against that, my lord, the others appellant has filed an appeal.
Okay, we'll just see there is no appearance.
Madam,
for
if-
the-
Yes, but kindly it may take.
It will be in the list only, we will see.
My lord, tomorrow and day after tomorrow I will be out of station.
will be in the
Kindly
list.
it be taken tomorrow, Monday, my lord.
It will be in the list, Mr. Pralad.
Madam, if it is taken Monday, I am much obliged, my.
Shall we post it for Monday? Just re-notify on Saturday, on Tuesday. Tuesday or no?
11, 12. Sir, 11, 12.
Much obliged.
7. Serial number 7.
For respondent, my lord, in this. Appellant filed the appeal regarding the set aside the commercial OS 459 of 21. So in this, I am a respondent. Here, he asked for the set aside the award what is given by the trial court. So on that basis, he filed this appeal.
Just leave it in the code. We'll leave it, we will have it in the list only, ma'am. We will see. Next, ma'am.
Serial number 8.
Just next 9. That's all?
Sir.
Okay, we'll get up now.
Serial list one serial number serial number 10 the memo, we have filed a memo for withdrawal, kindly refund the court fee. Court fee.
How much is the court fee you deposited?
Court fee around
Yes, yes. And there are some judgments that we should listen to. Just like compromise. Yes, yes.
We'll do one thing, we'll take this.
Lord, huh?
We will say that you file a separate application for refund of court fee.
But kindly, another application is required. I think kindly pass the order.
You should file application for refund of court fee.
We'll ask for the report
Then I
also,
will, then I will file. Kindly give a liberty to the appellant to file
so we are
application.
saying so. This has been
Grateful.
filed a memo which reads as under. To stop in view of the memo, the appeal is dismissed as withdrawn. Insofar as refund of court fee is concerned, the liberty is granted to the appellant to file an application in that regard. Okay, have you heard it?
Grateful.
Appeal dismissed as withdrawn.
Make one special. Lordship, I have given the book of Commercial Courts Act.
Okay, just show us. You have authored it?
Yes. 21 edition.
Oh. This is.
Yeah,
You are updating it also?
Yes, my lord.
This
month I'm
much
planning.
water has flowed.
Lot of,
And even the amendments.
yes, my lord. Amendments has come. I've got amendments to the Mediation Act, which will also be.
That's right, but amendments, 21 amendments incorporated.
Yes.
Would we keep it?
Yes, my lord. Thank you for the lordship. If the court has time, I would just explain what I have done so that 2-3 minutes. Lordship, may kindly see. Go to page number 819.
ಮಾಡ್ಕೊಂಡು ಕುತ್ಕೊಂಡು ಬರ್ತಾ ಬಿಟ್ರಿ ಶಿವಕುಮಾರ್ ಸರ್ ಒಂದು ಹೇಳಿದ್ರು ನೋಡಿ ಅಂತ.
Yes.
Called it as practitioner's manual.
ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರು
Part 3, where I have put all the pre-institution mediation rules in a tabular column and put the obligation, who has to do it, what is the requirement, what is the number, it's a tabular column in 2 pages.
Yes.
It helps the DLSA, it helps the parties in knowing how it has to be done. So you ought to put the entire PMM rules, I put it in chart wise. Including the fees, duration, etc., all that is mentioned. Next page, my lord. 821. I called it as easy find plaintiff. If I have to draft a commercial court plaint, what are the ingredients required for a drafting of a commercial court plaint? Which are the provisions?
Yes.
For example, 2(1)(c), definition, jurisdiction and all that. Similarly, easy find defendant. For example, 120 days written statement and so many other things.
Yeah, and you have referred to those judgments Supreme Court, commercial court.
Yes.
Act 120, the mandatory nature.
Yes. Then easy find court. The judge, as a judge in the commercial court, what are the things which he has to keep in mind? Cost, etc., etc.
Role and powers of court,
Court,
case management,
yes.
impose cost.
Then easy find all, that is to say court, plaintiff, defendant.
All means everyone.
All three stakeholders, that is a. Then 847, my lord. 847. Starting from the stage of pre-filing, what are the obligations of a practitioner to find whether it is a dispute which is covering under commercial court or not? Each stage, plaintiff separate, defendant separate, court separate. I made it separately for all three. I have almost staggered it to 7 stages in different stages of commercial court. So each one, every stage, plaintiff what he has to do, defendant what he has to do, what is the court supposed to do. For example, there is some misnomer that summary suit under Order 37 and summary judgment under this provision are the same. It is not so. I've also given distinction there saying that it is a different purpose and this is a different purpose. Last may kindly go to 894, I think, 894.
You have referred to those sections of CPC which have been amended?
Yes, I'll come to that little later. 894 is the one I've given a tabular form as to how the denials and admissions have to be made. 893, if I'm right. How denials and admissions have to be made in commercial court by the parties.
Yes.
For sample format,
Admission denial,
admission and denial.
affidavit.
And the affidavit format, because the law, the act doesn't say how it has to be there. So affidavit is also given there. And then next is the case management hearing, how it should be. Different stages, a sample format, including the judge commits to a date, saying that I'll give the judgment if you follow this by this date.
It's good, very good. Now, case management hearing,
Yes, my lord.
we have gone by the otherwise, I don't know, where is it insofar that this thing concerned, maybe there were rules also. You have these dates which you have given based on what?
It's a sample format which I've given, that's all. How it should be done. This is a,
Okay, that's your, this is
yes,
your
yes, for the
making.
purpose, yes, it's my own making. In fact, I came to know that some other judges, not only the commercial court judges, some judges in the civil court are following this in some cases. They say objection has to be filed by this date. To hear will be on this date. The defendant will be heard on this date. They give 3 dates at a time.
Yeah, otherwise that's the intent. It's a different thing that the case management is not
Correct.
followed. But if strictly follow,
Yes,
this should be the way.
yes.
In foreign jurisdictions, all dates, there would not be any adjournment.
Yes,
You need to follow that.
yes. 1021 may kindly be seen.
Which one?
Page 1021.
021.
I made it FAQs. For a non-legal man also, you can just get an idea of it.
On commercial
On
courts?
commercial courts. For example, a doctor, can he ask for fee under,
But you have included Justice Joseph judgment on 12A.
my lord, that has come later. That's what my revision is, at least 25 judgment per court now.
But there is one judgment of mine
Yes, my lord.
where, the very interesting point, it has arisen there. The pre-litigation was not before the Legal Services Authority.
Ah,
It was before a mediation center.
hmm,
He applied for the mediation center.
yes,
The trial court dismisses it that it was not before the Legal Services Authority. I will not recognize it.
hmm,
It was an ex parte.
Ah.
He says, even if I go to the Legal Services Authority, what will happen? The gentleman is ex parte, he is not coming forward. But I have to follow 12A.
yes.
Where is the settlement, pre-litigation, pre-initiation litigation? It will not happen. It's just a foregone conclusion, it will not happen. Now he has dismissed my suit.
On
What
merits,
shall on the ground that you did not go to the
pre-litigation.
Legal Services Authority, because it's
That's what
contemplated
PLM.
Legal Services Authority,
Pre-institution, PIM.
pre-institution. He is ex parte, he is not coming. I have asked him to come, he doesn't come.
Hmm.
What can I do? So then, obviously, in that scenario, we allow that suit, we have restored it, we have sent it back, ex parte evidence recorded, then proceed in accordance.
Lakshmi, kindly go to 148 last. Page number 148. Lordship asked whether you included the schedule to CPC. Schedule to CPC for commercial code, whether it is included. I started the page, I think, with 148 in the top note. Let me kindly see if I'm right. On the top, I made a note saying that around 148, 150, I think. 148. 148 ಅಥವಾ 150.
Yes.
I've said that wherever there is an amendment to the commercial code as per the schedule, is separately identified.
Amendment to the CPC.
Yes.
In terms of commercial code.
Yes. Now, Lordship may kindly go to 166. 166. The same CPC sections which are there. Lordship may kindly see some of them are bolded there.
Yes, yeah, see.
That is the insertion. I put it in the CPC as to where is the insertion of commercial code.
Substituted insertion.
Bold is the portion where it is inserted, schedule is inserted.
What is A?
A is, it applies to all.
C means?
C means court, P means plaintiff, D means defendant. So if I'm in a hurry, I want to know where I have to search, I can see from that itself. Plus, I have also give a corresponding illustration in my own way in the respective pages. What is that amendment about? This was 50% of my work.
You've done good. How much time it took for you to do?
Lord, I started it on the day when the central government announced lockdown. Ended when the lockdown ended.
So you utilized the COVID.
Yes.
Blessing in disguise.
Yes.
Good, thanks very much.
Thank you, sir.
Forward is by Justice Oka.
Yes, my lord.
Yes, sir.
My lordship, serial number 7, my lordship.
List number 2 repeat ಆಗುತ್ತೆ sir.
Madam 7 ಏನಾಯ್ತು ಮೇಡಮ್? ಹಲೋ
Sir, list number 2 serial number 7 ಶಿವಕುಮಾರ್ ಅಲ್ವಾ ಸರ್?
ಹಾ ಮೇಡಮ್, ನಮ್ಗೆ ಟೈಮ್ ತಗೊಳುತ್ತೆ.
ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರ್.
ಸರಿ.
ಹೇಳ್ಬೇಕು ಇಲ್ಲಿ ತಗೊಂಡ್ಬಿಡಿ ಅಂತ ಹೇಳ್ಬಿಡ್ಬೇಕು. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹಾಕ್ಸ್ಕೊಂಡ್ಬಿಡಿ.
ರಿಪೀಟ್ ಅಂದ್ರೆ ನಾಳೆ ಮತ್ತೆ ಹಿಂಗೆ ಬರುತ್ತೆ ಸರ್, ಸೇಮ್
ಸೇಮ್.